Yes, ma'am.
This is a writ appeal. Mentioning a writ appeal, the urgency is that the opposite parties, respondents, have already initiated a surcharge proceeding, and the impunity of the order is that the a third case has been made out, which is not the case of the petitioner.
Malas, may I be permitted to mention one matter, Malas? Malas, this is a query mining matters. Query mining matters.
Lordships, item 29 in today's list, my lord, it is actually for orders. There's an IA which is for orders as the writ petition is infructuous. It has come under the section admission. Lord, I pray either it may be taken up after all the items under orders or before the end of the list.
IA stating that it has become infructuous. So what? It has actually become infructuous.
My lordship. The IA is because the writ petition has become infructuous.
So have you informed the other side, because they won't
The
know
other
if we
side
take
is
it out
also-
after. All right. Abhi, we can take it up now.
My lordship.
Pardon, my lord. Mention, my lord. I mean GC, my lord.
All right, send your
WC number 277.
send your slip.
Obliged, my lord. Obliged.
29.
Lord, item 29, I am the respondent and the authority has already cancelled the tender which was challenged in this writ petition. Appropriate orders.
In light of the same, the rate may be disposed of.
So what is your name, please?
Preetham Pradhan.
Preetham
Pradhan.
Pradhan. Okay, you're there on record. All right. So your memo is there or IA is there?
IA, my lord.
Which one?
It is in flag
3092.
12770 flag E.
All right. Yes, thank you.
Obliged.
Matters under the heading for orders. Item number 15.
This case, there is delay of 424 days and notice on a limitation has not gone, but it is written postal tracking showing the showing out of delivery.
Office note indicates that the postal tracking report indicates that the notice was out for delivery. Hence, list the case on 28/11/2024. Registry shall download the up-to-date tracking report and tag it with the file. And registry is also directed to verify if any counsel has appeared on behalf of the respondent and indicate his her name in the cause list.
Item 16.
There is delay of 547 days and notice issued on limitation that is sufficient.
Office note indicates that postal tracking report is back with the noting item delivered. Since no counsel appears on behalf of the respondent, list the case on 28/11/2024. List the case on 28/11/2024. Registry is directed to verify if any counsel has appeared on behalf of the respondent and indicate her name in the cause list.
Item 17.
Delay of 543 days, notice sufficient man from the litigation.
Same.
18.
The delay of 209 days, man, notice also sufficient.
Same. Only thing that dispensing with, when will you file the certified copy of the judgment?
2 weeks, my lord.
2 weeks. Say, achhi joda re dekhi the I think there is one in 15. 15 that is there. 16 also it is there. 17 also it is there. 18 also is there. 2 weeks time. 2 weeks time. Then 19.
Item 19.
19, 103 days delay, notice return unsought, my lord. Whether 18 or unsought notice on the back.
Office note indicates that postal tracking report with respect to respondent number 1 indicates that the notice was out for delivery, full stop. Postal tracking report registry note indicates that the postal tracking reports in respect of respondent number 1 indicates that the notice was out for delivery, and in respect of respondent number 5, the item had been bagged. Full stop. The note also indicates that the notice on respondent number 3 is back with the noting that no such address in finance department. It is your own department. What address have you given? In Secretariat, Bhubaneswar. Please note the noting regarding respondent number 3. Check the note address. Check the address.
Respondent 3. I'll take test it.
Without checking, why are you saying? Please see who they are. May not be necessary. You don't have the file?
Hello?
Don't you have the file?
No,
Very strange. How can you come without the file?
the file is there.
Then please check who's respondent number 3. And you also have to check who's respondent number 4 and 5. Respondent number 3 is the private opposite party whose address, since he is retired, his address is finance department, obviously it can't be served. Acha, contact it also indicates that unserved notice on respondent number 4 and 5 is has been returned with the noting addressee left without instruction. Full stop. Since respondent number 3 to 5 are all retired employees of the are all retired officers of the finance department. There is finance department. The learned government advocate undertakes to find out the correct address and file the same
Right.
within 2 weeks.
Wait.
List the case on 28/11/2024. A registry is also directed to download the up-to-date postal tracking report in respect of respondent number 1 and 5 and tag it to the record. Yes.
Item number 20.
My lord, in item 20, there has been a delay of 318 days. And the certified copy, we have taken steps. Your lords may grant me 2 weeks' time. Within that period, certified copy will
Stamp
certainly
reporter says 287 days. 287 days.
oh, sorry.
So IA for dispensing with filing of certified copy, 2 weeks. And this, what is the subject matter? Why should we issue notice?
My lord, the respondent was never appointed anywhere. We have given sufficient documents, but without waiting for our response, the honorable single judge has disposed of. Asking
Was
that-
not an employee.
not an employee at all. All the documents we have given.
Where is that?
Documents I'll place, my lord. You will also
Not documents.
sorry, man.
Where is your plea before the single judge?
Please,
That is not there in the order.
No, because we were not given that opportunity to file those documents. We couldn't file a
First-
counter.
Where is the impugned order?
Impugned order is at page
Annexure
annexure, my lord.
1.
Yes. Impugned order, your lordship will find.
No, yes. For relaxing
Per
giving
7 years.
salary to the petitioner.
Yes, my lord. He has never been appointed anywhere. He has never worked.
Data entry. Engaged as data entry.
If your lordship comes to page 32 for a moment only, your lordship will come to know that.
No, there was a earlier order, I think.
Earlier order, yes, of a
To release the
coordinate.
financial benefit. Then there was a contempt. Then he stated you have taken away his computer and not allowing him to work.
That is the allegation, my lord. Since we didn't get an opportunity to answer, that is why these documents couldn't be brought to your the knowledge of the honorable court. Page 32 for a moment, your lordship may kindly see. Several documents there. Only one document I'll place.
Issue notice to the sole respondent on the question of condonation of delay a registered post / speed post, returnable within 4 weeks, requisites for which shall be filed by 20/11/2024. List the case after 6 weeks.
Item 21.
My lord, there is delay of 15 days, my lord.
21,
My lord.
you are the respondent. Mr. Mahanti is the
15
appellant.
Yes, I'm sorry.
So what is this case about?
My lord, here, my lord, the appellant before your lordships are the intervener in the writ petition, my lord. They have filed their intervention petition without giving opportunity of hearing. A order has been passed. The subject matter is that is construction of a kotha ghara, that is community center in village, my lord. When there is delay in sanction of money by the government, the villagers had collected money and they started the construction, my lord. And here, my lord, if my lord will go through the annexure 4, my lord, that is running page 56, the impugned order. The state had filed this counter and there they have taken averment that running page 56, my lord. Opportunity of hearing has not been given, my lord. And my lord, demarcation has already been done. State had filed its counter. That is one of the annexure, my lord. But without considering the same, again, a order has been passed to demarcate the land and demolish the construction made by the villagers.
I have to take instruction, my lord, from Tahsildar. What is it?
Already there is report, my lord. We are not violating.
Intervention has not been allowed.
No, my lord. It was listed and marked as flag B, my lord.
Your intervention was not allowed.
No, my lord. We have not given opportunity of hearing, my lord.
So have you filed any leave to file the appeal? See, you are not a party to the writ proceeding. You cannot challenge the order. And if you have to challenge the order, you will have to file an application seeking leave of the court to challenge the order. So whether you have filed any application,
No.
do that.
List the case on 28/11/2024 as prayed for.
Item 22. 26 days. Unanimous. Discipline proceeding ex parte.
Ex parte, what is the order?
Disciplinary proceeding by ex parte. Single bench order is on challenge. Annex 27 is the submission I have filed.
No, he is appellant. There's a
26
delay
day.
of 26 days. But what are you challenging?
Challenging the implementation compulsory retirement.
You are the petitioner.
I am the petitioner. Compulsory retirement was under challenge before the single bench.
Yes.
Compulsory retirement by way of an ex parte inquiry.
Oh, ex parte inquiry. I was wondering, I thought you were the petitioner. How can the order be ex parte? So what is the order?
I don't remember the compulsory retirement. That's what under challenge. Annex 21.
Where is the judgment?
Judgment impugned order, my lord, Annex 26.
Copy of the revision petition is Annex 26. ये PIL है Annex
Judgment
28.
was Annex 28. Again.
Annex
28.
28 है PIL.
28. I'm sorry, 28. The cost title is there.
No, the IAs are there. Though the bookmark indicates that Annex 28 is the copy of the judgment, but it happens to be contains the IA for IA also is very what's this?
I is separately bookmarked. Annex
Only the cost title is there along with the prayer.
20 is not copied.
No, that says page 184 to 197. Though the bookmark indicates that Annex 8 is the copy of the judgment which extends from page 184 to 197, But unfortunately, this page marking has been done incorrectly, as some IAs along with affidavits are included in those said pages. This is the case on 21/11/2024. In the meanwhile, proper page marking may be done. We are-
The pages are missing. 185 pages are. The rest of the pages are not.
Page 85.
Up to 185 pages. Rest of the pages are not there.
Either he has not given or office has not given. There's no page marking. 184, they have marked the wrong annexure. Just see. Annexure 28 is there. 185 is there. Thereafter, nothing. Have you filed the impugned judgment? There's no defect, so it is not his fault. It is scanning the section therefore. Yes.
From 23.
Maybe. There is
187
54 days delay in filing the appeal minutes. Because in fact, I was not made a party minutes. That is why I filed a separate application for leave to appeal. And that is at flag A.
Just one moment. I think there's a caveat there or something. Okay. What is the case about? Petitioner.
Here, what has happened? The present appellants are teaching and non-teaching staff of special school for blind and hearing impaired students.
Who
The
are
present
the-
petitioners and the
Okay, all right.
well, what has happened? On there is mismanagement, irregularities in the school.
Yes.
NGO was running the school. There are irregularities. That is, we filed a complaint. Basing upon that complaint, an inquiry was held. And after inquiry, you are held guilty, and your lordship may kindly see page number 31, Annexure 3 to the writ application.
Yes.
Because there, you lordship will see suitable or alternative arrangement for running the institution by other suitable agencies, management of the departmental may be made.
Just what are you referring to, please?
Annexure 3 at page 31. Annexure 3.
Of the writ petition.
No, exactly. Of the writ petition. Writ petition I have annexed as Annexure 1.
One moment. Just I've got the wrong case. 3021. Yes.
Let's philosophy permit me, I'll place minutes.
No, just tell us in short.
What has happened? There was withheld of alternate. There is direction for alternative arrangement for running of the institution and for appropriate action against the present management. Because that was challenged.
All right.
By the NGO. Because basing upon that writ application, because the honorable single judge allowed the writ application in not although in full allowed, directed that a fresh inquiry is to held, and at the same time directed that the petitioner should be permitted to run the management of the school in question for the time being.
Is that there?
Yes,
Because
ma'am.
it is stated that Secretary District Red Cross Society has
Yes,
been
it has been assigned with the actually presently also district Red Cross Society is managing the school, special school.
So where is it stated that he will be allowed to manage?
Page 57 you also may kindly see. Running page 57.
No, paragraph.
Paragraph number 9 of the honorable single judge.
Yes. Petitioner should be given a chance. Thorough inquiry should be done. Communicated and the proceeding committee were passed by the directs to run the management of the school.
Page note 57.
Got it.
And fresh chance is to be given to the petitioner to put for this position, and fresh inquiry is directed, but at the same time it was directed the petitioner will run the management of school, and inquiry there is no capping, there is no time period was fixed for conclusion of the inquiry. So he will run the for
IA number 7958 of 2024. This IA has IA number 7958 of 2024. This IA has been filed. This IA has been filed for grant of leave to the present petitioners to prefer the writ appeal challenging the order dated 13/8/2024 passed in WPC number 5509 of 2024. Heard Mr. Subhashish Patnaik, learned counsel for the petitioners, learned counsel for the appellants, oblique petitioners, perused the impugn order, full stop. The IA for we are inclined to grant leave to the petitioners to prefer this appeal. The IA is accordingly allowed and disposed of. There is a delay.
Yes, ma'am.
IA number 7959 of 2024. How many days delay?
54 days.
There is a delay of 53 days in filing the writ appeal. Issue notice to the respondents. Issue notice to the respondents by state is a party?
Yes.
Is the
Yes.
state a party?
Yes, ma'am.
Yes, ma'am.
Respondent number 2, 3. Acha. Issue notice to the respondents. Respondent number 1. Issue notice to the respondent number 1 by registered post oblique speed post with AD returnable within 4 weeks. Requisites for which shall be filed within by 20/11/2024. List the case after 6 weeks.
But 6 also notice I will take. 6 is the district director society. 6.
All right. Notice to respondent number 1 and respondent number 6.
Oblique.
Copies of the IA may be served on Mr. Bimbisar Das, learned counsel, who accepts notice on behalf of
2, 3, and 4.
respondent number 2, 2, 5. 2, 3, 4, 5.
Fine.
Yes.
I'm
6
sorry.
weeks, what is the date?
2nd January.
Yes.
I'm sorry, my lord, my matter will be kept on 22nd.
22nd, it can't be listed.
May I pray for short started because I have prayed.
That the office has to comply. You won't be available on 20th.
20,
Then 27th.
I will find. There was an interim application. Therefore, I pray shorter date may can use.
Okay, returnable within 3 weeks. List the case after 4 weeks.
12.
People also will permit, we will take also through special messenger, the shorter date can be fixed with the interim prayer is there.
All right. Just one moment. Where is the place? On Gold. Acha. Issue notice. No, considering the submission of the learned counsel for the appellant that there is some urgency in the matter, issue notice to the respondent number 1 by special messenger returnable with returnable by 21/11/2024. List the case on 25/11/2024. Cost for special messenger shall be assessed and paid by 18/11/2024 and paid by 19/11/2024. Yes. Good.
Oblique.
Yes, admission item number 1.
Yes, this is not maintainable.
Yes.
Mr. Counsel.
Is against this order
Sure.
of the civil judge 227 therefore of it.
All right. The appellant in the present writ appeal has put to challenge an order passed by a learned single judge of this court dated 29/4/2024 passed in CMP number 306 of 2024. Stop. An order dated 2/3/2024 passed by the learned civil judge, bracketed senior division, bracketed LR and LTV, Bhubaneswar in civil suit number 945 of 2013, whereby an application filed by the plaintiff under Order 11 Rule 14, read with Section 151 of the CPC, was under challenge. So stop. Next, the said CMP so and so has been dismissed by the impugned order. So stop. Learned counsel appearing on behalf of the appellant fairly concedes that this appeal against an order passed by the learned single judge in exercise of power under Article 227 of the Constitution is not maintainable. Stop. This appeal is accordingly dismissed as not maintainable.
Item number 2.
May I please, Your Lordship? Your Lordship, I'm challenging the order dated 16/7/2024 passed by the learned single judge, Your Lordship, wherein the prayer of the petitioner for a direction to the opposite party bank to return the documents lien to the loan account was dismissed, Your Lordship. Your Lordship, the petitioner, after clearing the loan outstanding loan amount.
Madam, the order is well reasoned.
Your Lordship?
The order is well reasoned. The learned single judge has assigned reasons referring to various decisions why this court exercising power under Article 226 ought not to have entertained your prayer.
Oblige, Your Lordship, but Your Lordship, the learned single judge has referred to Section 17 of the Surfacy Act as an alternative remedy, Your
Yes.
Lordship. And that is not the alternative remedy in case of the appellant for the reason that, Your Lordship, it only covers that whenever the measures that are being taken by the creditor, Your Lordship, if the applicant is
Surface
aggrieved
Act.
by those measures, then appeal is maintainable under this act, Your Lordship. Your Lordship, here a recent order was passed by the bank wherein arbitrarily they have just denied to return the documents even
Yes.
if I have repaid the loan amount in full, Your Lordship.
So how can the documents be returned to you?
Your Lordship, because the reason that they have given is since I am a guarantor in another loan account, Your Lordship. That is why they have retained the documents which were lien to the account that I have already repaid. And with all due respect, Your Lordship, the appellant had produced several judgments before the learned single judge.
No, just factually, if you are the guarantor in another loan account,
Yes, Your Lordship.
so the same property is not the.
No, Your Lordship. Two different properties, Your Lordship. And this account has admittedly has been repaid.
You are referring to which section?
Section 17, Your Lordship. Section 17, Your Lordship, says any person, including borrower, aggrieved by any of the measures referred to in subsection 4 of section 13, taken by the secured creditor or his authorized officer. Your Lordship, in section 13, subsection 4, it says, Your Lordship, in case the borrower fails to discharge his liability in full within the period specified. Your Lordship, it does not apply to me since I have completely discharged my liability and it is admitted. Because in the counter also nowhere they have countered.
No, that is not the question. Let us read section 17. Any person, including the borrower, aggrieved by any of the measures referred to in subsection 4 of section 13.
Yes, Your Lordship.
Any of the measures taken under subsection 4 of section 13, subsection 4 of section 13, whether there is a measure under subsection 4 or section 13 or not.
No, Your Lordship, because Your Lordship, I have.
Let us see that section. You're saying this is not part of the secured assets?
Your Lordship, none of these measures have been taken, Your Lordship.
No, not measures. The guarantee offered, the property offered by you
Yes, Your Lordship.
is not
Lordship,
part
that
of the
is-
secured assets in the other loan.
No, Your Lordship. That I have produced before the single judge as well, Your Lordship. The details of the same. And Your Lordship, I had referred to judgments.
Wait.
This case, your case falls within which part of subsection 4, according to the learned single judge?
Your Lordship, the learned single judge has not clarified regarding it. The only clarification given is section 17 is the alternative remedy. As per my submission, Your Lordship, is that I am remedy-less, Your Lordship, because my case doesn't fall under any of the measures. Rather, I'm challenging the arbitrary action of the bank in not returning the documents of a loan account which has already been cleared, and they are not
Cleared by way
disputing.
of auction sale.
No, Your Lordship, by me repaying the entire amount, Your Lordship. And they have not disputed that.
By you, borrower or
Borrower, Your Lordship. Borrower has.
borrower?
Yes, Your Lordship.
Then you're not the guarantor, you're the
I'm the
borrower.
guarantor in another loan account.
Okay.
So,
Husband and wife.
business partners, Your Lordship. And that is the reason that has been given by the bank, that since that loan is outstanding, that is why they cannot
From
return.
where can we find that the secured assets in this case is different from the other case?
Your Lordship, that was produced before the single judge, Your Lordship, in which two proceedings were referred to, Your Lordship. Both the loan accounts, there were two proceedings initiated, and in both the proceedings, it was mentioned that the
No. There is a submission on also argues that transferring the mortgage property without the bank's permission does not give the bank the right to retain the documents. No, the order.
This submission.
That is the submission.
Your Lordship, the learned single judge has.
Let us examine. That is
With
very
pleasure.
important. According to you, subsection 4 has no application in your case.
No, Your Lordship.
Let us see.
Yes, Your Lordship.
13.
Subsection 4, section 13. Come to subsection 4.
Yes, Your Lordship.
Issue notice. You are issuing notice.
Obliged, Your Lordship.
Now,
Item 3.
I note yesterday your lordship directed the state to serve a copy, and they have served him a copy of writ appeal number 1943 of 2024. There is a delay of 169 days. And my lords, can have a look to the application, condolation application file. There is absolutely no reason whatsoever. And that your lordship can see, they have They said that the knowledge, they could have the knowledge of this case on 21st of March
Forget
2020.
that, Mr. Rath. And donation, we will take care of. If there is any substantial question, we will decide.
September.
Yes.
You also can have looked at paragraph 3 of their application.
Don't forget,
Yeah,
let us come to the merits of the case.
Yes.
If it has no merit, then
My lord, so far as my writ appeal is concerned, my writ of
your appeal is not time barred.
2387.
That is not time barred.
No, man, that is mine is in time.
So, all right.
But their writ appeal which they have filed, my lord, is not the order against which I have come or Mr. Ratha has come. They have come in a different writ application. But all
right.
these things,
Let us
my
see.
lord,
Let us see who will argue first.
Yeah, no, just, I would
I-
suggest that let the state argue, because if state's writ is allowed, these two writ appeals will become infractions.
All right.
my lord, it will not be infructuous. With due respect to my lord.
Okay, may become infructuous. Let us see.
Yes.
Before my state files, my lords, I would like to draw my lord's attention that all these decisions, all these appeals are filed because of an order passed by collateral, by coordinate bench, my lords, can have seen that at page 100, which has resulted in this confusion, for which, my lords, these things has happened. This, that is, my lords, that at page, it starts from page 89.
In which WA
89 of my appeal. That judgment is also referred by them, also by the state. 2387 of 2024. This judgment is referred everywhere. You'll also kind of see 3 writ applications were heard. 10310
Where is that? 87.
at page 89 of writ appeal 2387 of 2024.
Annexure.
Annexure 9.
The 9 copy of the counter affidavit.
My lord, sat, please. My lord is taking 2387.
Yes.
Yes,
2387, my lord, and at page 89 is annexure 9.
Page
Of-
8.
The state.
89.
Oh, that is part of the writ application.
Yes, my lord. All right. And what I would like to bring, my lord, this
us-
order of the Honorable Single Judge has been challenged in writ appeal number 1528 of 2022, and that is pending. So, unless that is decided, the state appeal cannot be taken into consideration.
And who has filed that appeal?
I have filed. We have filed. The governing body has filed.
Yes, let us see where is that judgment.
Your lordship may see para 3 of the impugned judgment there, this about that rate appeal, it has been reflected.
Let us see. Where is that judgment? That judgment is on record.
Minus that judgment at page 100. It starts from 89.
My
Which
la-
page?
My la-
Page is 110.
my London senior offered not to praise that rate appeal.
But being aggrieved, I filed appeal. I didn't accept that order.
No, they have accepted. They've implemented that order.
No.
We'll show that. That's where they say
Let us
Slowly.
let us have grip over the issue first.
If your lordship will permit, I'll just give a very
So,
brief
so
account.
just a minute. So this against this judgment dated 18/10/2022, Writ appeal is pending.
Yes, my lord.
They are saying that.
1528
They are
of
submitting that.
2022. 1528 of 2022.
Okay.
22.
2022.
No notice has been issued in
No,
that.
it has not.
Just
It has not been listed, my lord. Yes.
not being listed in spite of your efforts.
Because my lord, basing on this, since state government has passed different orders, that is why those orders were challenged in different writ applications. But the main order against which the appeal has been filed, that is still pending.
Pending. Yes, sir. Huh?
Not listed at all.
Last listed on 18th August.
So what order was?
18th August 2020.
Order.
So whether this order has been relied upon by the learned single judge while passing the impugned order?
My lord, this order has been relied upon by the honorable single judge.
This is what we are saying. Can we hear all the
Your
appeals
Lordships,
together?
may I, if your Lordships will permit, the history of the case is this, that there was a governing body and its term was for 3 years. Thereafter, the government should have constituted, allowed a second constitution. But they said, no, let that governing body to continue for another year. And then that order was challenged that why are you allowing them to continue for a second term? Thereafter, they come to the writ court and the writ court passes an interim order and it continues for third term. So that's where Justice S.K. Panigrai's judgment comes up and it says that no, don't continue this. So this body which is continuing for the third term is also like 3 plus 3 and then again 3 and it's gone beyond. So the final order was that you give a fresh reconstitution and all the members who are continuing there should not be allowed to continue. That's also the requirement of the statute. So what the government did is, meanwhile, it kept the ADM in charge so that reconstitution can happen. That ADM order pricked the governing body, obviously because it can't pick its own people. They came and challenged that before the single judge. Then Justice B.P. Satpathy's judgment came. He said, no, let this governing body forward the new names. That order, of course, was not challenged. And only for the limited
That
purpose.
is the statutory requirement also. That the present governing body, yes.
Says only before the expiry of the term. Now, this is expired, gone, and outlived like anything.
19.
But here, Lordships, even if Justice Satpathy's judgment is to be taken, that the limited purpose, what the judgment was saying, that only send the names, don't do anything. They, using that order, remove the principal in charge. So that because the principal in charge would become the ex officio member there. So that their own people can be there. And then comes the third writ. And in third writ, which is filed by the principal in charge, that order, so this removal of the principal in charge was set aside. And all these matters are there before your Lordships. State is challenging that order of Justice Satpathy's order, where that ADM has been put out of control. Again, this board that same governing body has been put again in charge, and the whole issue has been put forward. So all that we are saying is, let the ADM again be in charge. And today what has happened is the principal in charge is somebody who is not even of this college, is some other college. And that has been done relying upon a judgment which does not apply here because we are unaided college, that's an aided college. Two different set of rules are there. So this is how the whole thing is. If this order which Justice...
So this is unaided college.
This is unaided college. If Justice S.K. Panigrai's judgment has been challenged by Mr.
By whom?
By
ADM.
Managed by the ADM.
ADM is not in charge.
ADM is not in charge.
So all
who is in charge?
The same governing body because of the second order.
Who had established?
Yes.
Yes. Obviously, that trust and that governing body. The statute requires.
All right. So where is the statute?
Let me just show the 1991 rules.
Just let us be clear about the law first.
Yes,
then we will see. We are just interested in understanding which law is applicable.
Yes, let us first see definition, my lord, because law flows from that. Your lordship can have a look to page.
Rath, we should have the book first, and then we can see the definition.
Yes, yes, ma'am.
And
Yes,
then the provisions.
yes, ma'am.
So you are there to guide us.
Yes, my lord.
We cannot go beyond your guidance.
Yes, my lord. Book is there.
Yes.
Which rules?
23, Rule 20,
Rule 20 of?
23 of
91.
1991. Is it a page?
Step by step.
690. Your lordship will find that in page.
Just
number
a minute. Just a minute. So is there any dispute that this Odisha Education Rules 1991 is applicable?
No dispute.
No dispute.
Yes. What is the definition? Which definition you are referring to?
My lords may have a look to page 115.
तापर अलगा page.
No. Page 1, say boy.
ना से बही.
My
We are seeing the rules.
Give us
Just
the-
Yes,
see-
my lords.
give the-
I'm placing the rule section. First, my lords, I'm placing sections 3 of the Odisha Education Act.
Section 3.
Yes, my lord.
First if you wanna.
Yes.
My lords, I'll be relying on section 3B, H, O, and P. P defines aided educational institution.
So you are not.
Which
This
I am
college
not.
is not.
Yes,
Huh?
my lord. Then my lord comes.
Just a minute.
Yes, my lord.
So it is not aided.
Yes, my lord.
H.
Then thereafter, my lords can come to O.
No, what about
No,
H?
H governing body.
No, my lord. O comes private educational institution.
Okay.
Yes.
Means any educational institution which is not established and managed by government of Odisha, the union government or government of any other state. I am not coming within that because it is not established by them.
Just a minute.
Yes. Why won't you come? It says which is not established.
Yes, ma'am. My institution is not established by any of them.
So
It's a
this-
private.
So it come under O.
Oh,
It will come under O.
yes, my lords. That is why
Yes.
I'm kindly bringing to my lords
Yes.
notice.
yes.
I am coming under O.
All right.
Yes.
Then my lords can come to P.
Yes.
Recognized educational institution.
Yes.
Means any private educational institution which is or has been recognized.
Yes.
I come under my lord. I am a recognized private educational institution.
Huh?
Yes,
You are?
I'm a recognized private educational institution. First I was established, then
No,
my
no,
lord.
where do you get this definition recognized? Where is the recognized?
P, my lord.
B, P. Yes. All right. You are P.
At this juncture, my lord, I would like to draw my lord's attention to section 7.
Yes.
My lord, section 7 relates to constitution of the governing body.
Yes.
And my lord, this governing body, as for 7, the managing 7.1, 7.2, my lord. the managing committee or the governing body, as the case may be, constituted for any private educational institution shall obtain the approval of its constitution by the prescribed authority in the prescribed manner, failing which the institution shall not be eligible for recognition. Then your lordship can have a look to that
4.
I am recognized thereafter, my lord.
So who is prescribed authority?
Prescribed authority, my lord, here is the director.
Yes. Prescribed authority defined. Yes.
Then my lords can come to clause 3 of that section.
Okay.
The managing committee or the governing body, as the case may be, shall be responsible for the proper management of the institution and shall exercise such powers and perform such functions as may prescribed.
Yes.
Then subclause 4. A managing committee or the governing body, as the case may be, shall continue in office for a term of 3 years from the date of its approval by the prescribed authority under subsection 2 and shall be reconstituted in accordance with the rules.
Yes.
Your lordship will learn now to see 7A, which came on amendment.
Then 6 also, probably 6 also is relevant.
My lord?
6 also is relevant because it
Yes,
says
ma'am.
after expiry it will
I'm
continue.
placing which is relevant for the purpose of my case.
All
ma'am.
right.
Whenever the prescribed authority is satisfied that the managing committee or as the case may be, the governing body of private educational institution has neglected or failed to perform any of the duties imposed by or under this act or the rule or to give effect to the order or direction issued by the tribunal under section 24A or has acted in exercise of the authority vested on it or in any manner which is prejudicial to the interest of the educational institution, he may, after giving the managing committee or the governing body, as the case may be, a reasonable opportunity of showing cause, supersede the managing committee or the governing body. That has not come to this stage. Our governing body has not been superseded. It continues term.
Your body is dead.
My body,
Your body is not alive.
my body is my.
No.
I'll
Your
come to
body,
that.
yes.
I'll come to that. Yes.
That is by operation of law. The law says after 3 years you cannot continue, or after 1 year you cannot continue.
No, that is not there. Sub-rule 2 may be kindly, subsection 2.
Just a minute. Consequence or appoint any person or persons to
Like
exercise
ADM.
the powers.
Like
ADM was appointed.
And that was subsequently. So earlier, I think they were continuing. Continuing on their own, or the prescribed committee allowed that they have to say.
ADM is appointed providing for the Constitution. You cannot. See, you were functioning before appointment of ADM.
Yes, my lord.
So how could you come back again?
There is no restriction, my lord. I will say from the 91 rule. It prescribes the authority. So far, the managing committee.
Prescribed authority can allow you to continue.
Yes, my lord.
Or appoint any other person.
My lord, in this case, they cannot appoint anybody.
Or appoint any person or person.
In 1991 rule, I will be placing it.
Yes.
It is only when we have been, the governing body was continuing. Thereafter, my lords, the governing body was approved. That approval governing body was rejected by the government. The writ application was filed. This honorable court gave a stay order. Accordingly, they have been continuing. No,
So
until then, there is no reconstitution of governing bodies till to date.
But
Therefore,
that
under
was
this 7C,
ADM, like any other person can be appointed. This he has been appointed.
my lord, that was challenged and that was quashed. The appointment of ADM has already been quashed.
So that is the one which is under challenge by the state.
A private institution, my lord.
Please read subsection 6
Yes, ma'am.
of section 7.
Subsection 1 or 2, my lord?
Subsection 6
Six,
of
seven,
section 7.
7, 6.
This is after
6.
5.
My lord. Section 6.
Yes.
Recognition of education institution.
Subsection 6 of section 7.
You have read the previous.
Yes, ma'am.
So 6 you had left out. So 6 is relevant.
Yes, my lord. The prescribed authority may allow the governing body or the managing committee, as the case may be, whose term has expired under subsection 4 or subsection 2 of section 7A, to continue in office till the governing body or the managing committee is reconstituted, or appoint any person or person to exercise the powers and discharge the functions of the governing body or the managing committee during the intervening period. Here, my lord, what has happened?
Please come to the proviso.
Provided that the state government may reconstitute the governing body or the managing committee, as the case may be, notwithstanding that the term of such governing body or managing committee has not expired on or such reconstitution, the existing governing body or governing body, as the case may be, shall stand dissolved.
Yes.
This has not come, because, my lord, it has not been superseded. The governing body, which was continuing in a private, unaided, recognized institution, they have been continuing, and after the term was.
So you will continue till when?
My lords, I was continuing till it is reconstituted, my lords. Because we don't say that will continue. We have submitted a proposal that has not been, it is pending with the authority.
Yes.
Until it is reconstituted, according to the provisions of this statute, we have to continue, and that continuance cannot be taken as a term. That was the dispute before this at the first instance.
So that writ appeal 1582 of 2022 challenges what?
My lord, regarding the fixation of term, because in earlier petition, my lord, when the term was yet to be
All right.
expired,
What is the procedure for reconstitution?
my lord, the erstwhile governing body will submit the proposal.
Where
My
is
lord,
that?
prior to that, my lord,
Where is that provision?
That is not expired.
That is under the rule, my lord. Now you're not.
Yes, yes.
Which rule?
Yes.
I'm placing the rule, my lord.
Yes, yes.
That rule, my lords, will catch it at 91 rule.
Yes, you got it.
Three hundred, 600, 301, 600.
681.
Rule is at 681. But chapter 5.
Yes, my lords.
Chapter 5.
681, yes.
Yes.
Your lordship can come to.
Yes. What is the procedure?
Yes, ma'am. We come under this rule 21, 22 only. Rule 20, 21, 22, and 23.
23.
Under Rule 22, we have been approved first.
Rule 23 is relevant.
Yes, madam. Yes, ma'am.
23.
Then under 22, we submitted the proposal. This proposal was approved by the under Rule.
The 90 days of date of expiry. So you have done
Yes,
that
my lord.
before 90 days.
That was submitted. I will place under
When
the
did you submit?
minus we submitted. That was challenged by in the Justice Panel's order, my lord. Your lordship can have a look to order. It is
So when was this governing body constituted?
First.
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 That was, my lord, in the year 2007.
Date.
It was, my lord,
Date.
1/6/2007.
1/6/2007.
1/6/2007.
So 3 years would be 30.
Where is
10.
the 3 years?
Sorry.
Where is the 3 years?
Yes, that is rules section 7.
Oh, because of section 7.
7(4).
On 26th of February 2010, my lord.
Just a minute.
My lords, first of all, my lords, they asked for the provisions of all the governing body was approved on first April 1/6/2007.
Yes. When did you?
Then it was accordingly proposal submitted on 26/2/2010.
26.
2010.
Under Rule 23.
Yes, my lord.
Yes.
Under Rule 23.
Yes. So
Then-
what happened on that?
On that, my lords, the governing body.
Approve it.
and they kept it pending, my lord, till 2013.
Then what happened?
My lord, 2013 they approved.
Okay.
And
Just a
when it
minute.
was,
Let him say. Let him.
my lord,
Approval of the contract.
All right. So after 31/5/2010, what happened?
my lord, after 2010, the proposal was submitted and government kept it pending without approving the same, my lord, and allowed this governing body to continue, my lord, as an intervening governing body.
Allowed to continue by an order or just it happened?
an order,
by-
The specific
By an-
order is there.
Yes, my lord, specific
When,
order
what
was
is the date of that order?
That is,
And ultimately, by the 30th of December 2013, the governing body was approved. That your lordship will kindly get it
No,
at
that where you're saying allowed the to continue as an interim.
page 7 of our, page 7 of our, writ of
Writ
appeal,
of
lordship
appeal.
can level it.
3/7/2010. That's there in the judgment.
Okay. No, but we want.
37.
2010.
10.
2010. What is that?
They allowed that same body to continue
Government.
as an interim body,
Interim body.
same governing body.
The prescribed authority.
Prescribed authority.
Yes.
Okay. Then 13/12.
2013.
30th of December 2013, the approval was made
Of the
for the
same-
period of 3 years.
So the proposal given by you in 2010
Yes.
was approved in 2013.
13. My lord.
The second term.
30/12/2013.
the same governing body was allowed to continue now.
2013.
Yes,
Yes.
ma'am.
32.
Till till
approved governing body was made on 30th of December 2013 for a period of 3 years.
Yes.
While that was the prescribed authority has passed that order. This order was challenged by a stranger, challenging that this governing body has been, the private governing body has been constituted, approved illegally. And when this order, this was challenged, thereafter, my lords, this honorable court allowed the, gave a direction to the authority to consider the representation made by the stranger. And while considering the representation, the state government opposite party number 1 passed an order cancelling the governing body and appointing ADM as the some authority.
That was when?
Yes, madam.
Date.
31/5/2014.
31.
31/5.
2014. That is most relevant. That document your lordship may see.
So the approval was cancelled.
31 May 2014, dissolving the approved governing body.
Dissolved.
The term was of 2016. This was challenged. This order of the government was challenged before this honorable court in the writ application where
Number.
1031, WPC number 10310 of 2014.
14.
13.
10310 of 2014.
Yes.
That writ application was decided that the order passed by the government was justified in that writ application by Justice Paningrai.
By which order?
By the order dated, that is the 18th of October 2022.
So that means that writ petition was dismissed.
This with the observation.
With the observation that this governing body, which was continuing beyond the period, etc. But any that was contrary to provision that has been challenged in writ appeal, that is pending.
That one. 20. That
This
was-
order.
That 22 which.
Yes, my lord.
Okay.
This
Yes.
22 order is challenged in writ appeal number
1528 of
1528 of 2022. And because that is order is pending, taking the observation made by Justice Saring's order, the Panigrai's order, the next order was passed that since this was observed there, therefore the order passed subsequent order, those are in this present writ appeal. So first order is of,
That will have to be heard together.
yes, ma'am.
That writ appeal.
Can I
Because
just
it is-
clarify?
Because one thing is, there must not be an interim order there.
There is. That's the thing.
Uh-huh.
So today they have
In that writ
overstayed.
There the writ appeal is an interim order.
No, not with
No,
the
no.
appeal. In
In
that
that
single judgment. So what happens is from 6 to 10 they continue.
Whatever you can blame the court, but it happens.
No, but I will not blame the court. I'm only going to say that how does the position look vis-a-vis the statute? I will never blame the court. I'm part
No.
of this institution. I'll never
No, we
blame the
should.
court for that.
At times, if there is, if because of some interim order passed by the court, something is delayed, then yes.
That's the
in the
observation
process,
also.
yes.
In fact, the single judge had the humility to actually, your lordships, a single judge actually had the humility, and he said that you have continued from 2006 to 10, then from an interim period till 2013,
Oh.
and then till 16, and now you have overstayed
No,
for
so-
11 years.
So there is no stay to that order. So court need not be blamed. Only you can be
So,
blamed.
your lordships, what really happens is,
What is the
Number, man,
uh,
1528 of 2022.
after having heard Mr. So and so, we are of the opinion that the legal issues which arise in the present batch of appeals are integrally connected with the issues involved in WA number 1528 of 2022 against an order passed by a learned single judge of this court dated 18/10/2022 in WPC 10310 of 2014. So stop. This matter on next week.
Yes, ma'am.
Good. 2 p.m. may I have the time?
can I have a small prayer? Now, your lordship should imagine that this same body now has been continued since 2007.
Therefore, we shall expedite. We shall do two things.
We can have the ADM being in charge. That's
No,
all
we
that
shall
is.
do two things. We shall hear, all of you, the correctness of the order. Of course, we shall go into, but we shall ensure that a governing body is constituted during the pendency of the proceedings.
Yes.
So that shall give finality to everything.
But one more thing is, your lordships, that, the governing body's recommendation, according to Rule 23, and if your lordship look at the facts, cannot be made by them. So that's why I'm saying
that aspect we will examine.
If the ADM today is put in charge, that college will actually be in safe hands.
See, if we find some force in the submission which has been made, and that, of course, that is also subject to the subsequent development that ADM was appointed. Otherwise, the prescribed authority ought to have acted upon the proposal which was made in 2010, February 2010.
They kept it
For
for
reconstitution.
So it was to continuation of the same body.
Okay, one way it has actually been.
The
taken
proposal was to continue that same governing
We
body.
will see that.
Yes.
There is a
So
bar. There is a bar. One cannot continue
not
more than 2 terms.
Beyond 6 years.
No. Therefore, we shall see whether that proposal was in accordance with the provisions under the rules or the act.
Yes.
If the proposal was contrary to the rules or the or provisions of the act, we shall hold that cannot be treated to be a proposal within the meaning of the provisions of the rules. All right.
Today they have sent a fresh proposal. That's the problem.
We will examine. That's we are listing it after a week. We shall ensure that in the meanwhile this exercise is complete. There is unnecessary litigation in educational institution matters.
If you look at it, that proposal has actually been approved. They have worked for 3 years.
No,
So
3
that is
plus
over. That is over.
Yes, so therefore today they are actually legally non-existent, but yet they are control of the things. Your lordships.
And in the meanwhile, if you could ask Mr. Tibrewal or Mr. Mahapatra,
Next
we have
week,
made a
balance
date
update.
chart. To give us only a date chart,
Yes,
no
we give a
submissions.
proper date chart.
No submissions.
Date chart and statutory provisions.
Your lordships are calling this
Next week.
Your lordship, next week I have an issue. I'm not there from 19th.
When do
Your lordship, it keeps on 25th.
25th.
It's actually the first 5 cases.
Item number 4.
I'd file an appeal challenging the impugned order, my lord.
No. The only question is whether SC, BC is OBC or not.
Yes, my lord.
Your lordship, OBC is the central list, your lordship. And SCBC is the state list. It is state specific. So there are certain castes like Pandayat, your lordship, which is there in the SCBC list, but it is not there in the OBC list.
Right.
And as far as I was examining,
So what we were thinking that SCBC is part of OBC is not correct.
no,
Entirely not correct.
not,
Okay,
not.
all right.
No, you're right. That will depend on the list.
Yes,
That will
your lordship.
depend on the.
It is like these sets. Right. Common, but.
Your lordship, in this, the Manjula community, it is included in the SCBC list at serial number 208.
No, this can happen.
Yes.
8.
208.
So what is his caste?
First one I think is Manjula.
Manjula. Petitioner number 1 is
Wait, let
belongs
us
to
find
Manjula community.
208. Manjula, and that is the SCBC.
Serial number 4 is my case.
Yes. First we are. Referring to
The second.
case of Mr. Jina.
Second.
No. What submission he is making relates to his case, because the question of Manjula doesn't arise in his case. You're making
The
submission
second
to
case.
Jana's case.
The,
Acha.
the
In the second
The writ petition, Your Lordship.
Second writ petition.
Second writ petition.
Second writ petition.
Yes.
S. Jayashree and others.
Yes. Second writ.
Writ petition is an appeal.
That is writ petition. Second writ
It's a
petition.
writ petition.
Second writ petition.
Second writ petition. WPC 25371.
25371.
There yesterday, Your Lordship.
It was before your lordship and yesterday.
Yes, yes.
Nursing admission.
Nursing admission to the 40%.
We are on the BPCL, Bharat Petroleum, the first writ appeal, 2484.
These are two different issues then.
Yes.
Yes.
One will depend on the state list and the other will depend
Yes,
on,
ma'am. That is the common issue, madam.
that is the,
Common issue in both admission and the selection.
Different because number of
Not
castes
only
are involved there.
Exactly, not Whether- common, that's a different issue.
You understood,
And the
understood.
BPCL.
so we will take up WPC first.
Yes.
WP 25371.
Yes, ma'am.
Yes, Your Lordship.
Yes, you are what?
Mal.
10 petitioners.
I in the petitions.
No, 10 petitioners, I think, or only one.
Five
petitions.
petitions.
5 petitioners.
petitions.
Okay. All different castes.
Five petitioners here.
If
And
I'm
your
not-
lordship, first one is belongs to Manjula community at page 30.
You have given a note, no?
Yes, Manjula community is
Ah, so we have
SCBC
to look for each
and
petitioner's
also
caste.
OBC, Your Lordship. It
Wait,
is an OBC central list at serial number 199.
Wait.
No, there is no question of central list is for the central this thing.
No, Your
When you
Lordship.
This is all India. I
It
think.
is OBC other backward class that has been classified by the central government, Your Lordship. And SCBC is classified by the
Oh.
state government, Your Lordship. Every state it might differ. Some
So therefore, we are saying
yes.
that what is OBC for the central government is SCBC for the state government.
Some OBCs may not be SCBC also, Your Lordship. Not all OBCs.
You are
are
right.
SCBC. Yes.
Some OBC may not be SCBC,
Yes, Your Lordship.
but all SCBC are OBC for the state.
Some may be, Your Lordship, because
no,
there
you
is
are
a
saying-
Dambu
Because this is
Christian-
your list.
You are saying state doesn't have OBC.
No, Your Lordship, because there is a Dambu Christian, the petitioner number 2 and 5. They're Dambu Christians, Your Lordship.
Uh-huh.
Dambu community belongs to the scheduled caste community, Your Lordship.
Oh, so that goes.
So Dambu Christian is included in SCBC.
Oh, Dumbo Christian. That is where
Christian,
they go.
yes.
So Dumbo Christian, therefore Dumbo Christian is SCBC, not SC, not ST,
Not SC. SC.
not SC.
Yes, Your Lordship. But they're not OBC, they have SC. So some from OBC, some from
So
SC.
this dispute relates to admission.
Yes, Your Lordship.
Admission to
Nursing,
BSc nursing.
BSc nursing
nursing in a
Education.
state.
in the
Yes.
state.
So which is the list applicable?
The SCBC, Your Lordship, if they are seeking reservation, they like Dambo Christian petitioner 2 and 5, they are belong to SCBC. They don't belong to
So
scheduled caste.
OBC doesn't concern us.
No, Your Lordship.
You only go by the SCBC list.
SCBC.
Is this your submission that SCBC
Yes, Your Lordship.
of the state of Odisha are not OBCs?
Some are OBCs, Your Lordship. Not all.
Some are OBCs because they find place in the central.
Yes, yes.
No?
Okay, one question. Who will grant the certificate? The state?
The state.
Right.
So what is the meaning of OBC?
It's a list that has.
Because each individual.
Let us see your SC. See your SCBC. You will have to follow this. Where is the reservation rule?
Can I pass it on, my lord?
Not your.
No, no,
state.
same, that
Same
rule.
rule, same rule.
Same.
It is very clear. Just come to section. This is rule.
2B.
Act section 2B. And where is this? Odisha Reservation of Posts and Services, Socially and Educationally Backward Class Act. SCBC is OBC for you.
Yes, Your Lordship, but not all SCBCs are OBC in the central list.
Not you'll have to forget central list
Yes,
for
Your
the purpose of state admissions in state institutions and employment in states.
Yes, Your
You will
Lordship.
have to forget that because this is your list. The persons who are there in the central list, they may not be entitled to for appointment in state or admission in state institutions.
Yes, Your Lordship.
They are OBCs for you.
Like, Your Lordship, Khandait caste, which is SCBC at 136 serial number, SCBC list, they're included, but they're not included in the OBC
Exactly.
list.
Exactly. So they are OBCs for Odisha, but not for in the list of the central government.
Yes, Your Lordship.
Or you cannot be considered, this caste cannot be considered for other states.
Yes, Your Lordship.
Because they have their own list.
Yes, these are
You
all
have
state
your own
specific.
list.
This is state specific.
So this is state specific, then
Yes.
therefore you will have to honor that, respect that. You cannot say that because this caste does not belong to find place in the OBC list of the central government, therefore they are not entitled to. So even like those castes whose names don't figure in the central list, because they under the central list they are forward.
Yes, Your Lordship.
But for the purpose of a state, they may be treated to be backward. And this definition is very clear.
Yes.
The backward classes means socially and educationally backward classes as defined in clause E of section 2 of Odisha Reservation. Let us see.
Right.
This is SCBC.
Yes, Your
Well,
Lordship.
An act was also considered, SCBC Act. Section 3 provides 27% reservation for those persons.
One more submission.
All the petitioners belong to the SCBC, Your Lordship.
Yes, yes.
Right. So of course,
One more submission, my lord.
So for state seats, they'll have to honor SCBC.
I have downloaded a guideline. I don't know whether it is that guideline.
And another.
One more submission, my lord.
Who has the guideline? Please give it.
Let us see the reservation policy, the Reservation Act.
2024, my lord,
And the guideline.
No,
2024
Act. Where is the Reservation
guideline has
Act?
been revised, my lord, but same rules are there. Can I pass it? 2024, it has been applicable.
So your case is different because that relates to
I'll satisfy, I will come back. Case is different from this case. Official case is different from this case.
no, this is something else.
Earlier guidelines have been
This is-
superseded by these guidelines, my lord,
Huh?
but definition is same.
So this is a division bench matter or a single bench?
It's a writ appeal.
Where are the documents?
No, where is this? Odisha Reservation of Posts and Services for Socially and Educationally Backward Class Act 2008. Where is that?
Well, it's section 2, subsection E, definition. Socially and educationally.
Posts and services.
My lord, so far as this applicability is the SCBC. Section 3 provides the reservation of 27% for those which has been declared by the state as the SCBC in terms of section 2
So
subclause.
please come, madam, to section 3. Do you have a copy of the act?
Yes, Your Lordship.
Posts and services.
These are for service matters, Your Lordship.
Not only service, this will apply for admission also. Please request Mr. Advocate General to assess this court, otherwise
Your Lordship.
it
I'll take
We'll be
instructions.
laying down a law, or otherwise we believe that these aspects must have been addressed in some of the decisions.
So, Lordship, I was not present yesterday, Your Lordship, so in the morning.
Please examine. There are two
I'll
things.
take instructions, Your Lordship.
Don't get confused by this expression OBC.
Yes, Your Lordship.
See, OBC, that list prepared by the central government will apply for all the central government posts, admissions, or whatever. So they would need a certificate of OBC for central government and everything. Then the state can formulate, and your state has framed enacted an act, and you will be governed by that. So you cannot say that for appointment to a post in the state government, a person cannot be considered because the name of that caste does not figure in OBC list. See, you have decided to give that person benefit of reservation under this act.
Your Lordship, humbly admit that all these petitioners, they belong to the SCBC.
If they belong to the SCBC, then the state institutions,
Yes, Your Lordship.
and the state departments cannot deny the benefit of reservation.
They belong to the SCBC.
They belong, then.
They belong, Your Lordship.
So therefore, there should be clarity. There should not be any confusion that because particular caste does not find place in the list of OBC, therefore they should be denied.
Your Lordship, if I may, that Manjula community, petition number 1 belongs to the Manjula community. That is there in the 208, serial number 208 of the state lit of SCBC.
Therefore, how are they being denied? That is the question.
Not be denied, Your Lordship, because Dumbo Christian community
Then why are you?
is at serial number 193.
The problem is our prospectus doesn't say that.
You are which? Who are you?
For DMET, my lord.
DMET is above the state of Odisha.
No, my lord.
Then
the guideline for the admission we had given, that is SC/ST, and after minors judgment we have added OBC.
OBC. Have you defined OBC in your guideline?
No, man.
Then you will have to read OBC under this act.
That
OBC cannot be read. Be clear on the legal issue. We will take up the matter again on Monday. Monday, please request Mr. Advocate General to appear. Please tell him.
Yes, sir.
Because 30th.
This is the issue. Issue must be clear to all of you. Because you have two acts. Very simple. You have one Odisha Reservation of Posts and Services Act 2008, and the other Odisha Scheduled Caste, Scheduled Tribe, Backward Caste Regulation of Issuance of Verification Certificate 2. These are two provisions. You have the state list also. Whether the persons who fall in SCBC category can be denied appointment, employment, benefit of reservation in employment or admission on the ground that they don't find place in the
OBC list.
That's a good question.
Certainly not. But I will.
Because you will say, my lord, 30th November is the last date for cancelling.
What is the date?
30th November.
30th November, and that has been extended.
Before that.
That is up to 30th of November.
Up to
That has been extended up to
Extension,
30th. After extension, it is 30th. We will see. Try.
And pharmacy is to which date?
Pharmacy is also 30th November.
And you should be, in fact, these aspects should be resolved at your stage. There is utter confusion.
Yes.
And this is what I have been observing from the very beginning.
Right.
My lord, our serial, so far as BPCL is concerned, serial number 4.
We come together.
Let it come together. You are SCBC.
I am from the
SCBC. That's
I am
also.
SCBC. I have been duly selected. They have appointed me.
So therefore, for central government, you are not OBC. That is the difference between this and that.
Our case is central government.
Your case is
Exactly.
central government.
Our
All right.
Slightly different, but anyway.
All right.
It's a
All right.
notification.
All right.
The through a PIL, by the interference of this Honorable Court, the monument was declared as the notified monument, Government of India.
Yes, who saw the estate?
My lord, the entire some structure and boundary devastated, my lord.
File your affidavit.
Even central government is to file for the ASI.
Yes, who is for the central government?
My lord, Deputy Solicitor General.
File your affidavits. So,
Silent person.
issue notice. So accept notice on behalf of. File your affidavit, Mr.
Yes, yes, madam. We'll receive the PWs, madam. Certainly will pay.
Counter affidavits be filed on behalf of the parties.
You have received it in 2 weeks.
Already your PWs I have received.
PWC. 2 weeks then?
Yes.
Yes, madam.
May I pray, the miscreants threatening for further devastation.
Let us see.
State is to provide the necessary police help.
Let us see.
My lord, my lord.
We expect that
You also get instructions.
the opposite parties shall ensure that in the meanwhile, no further damage is done to the no further damage, comma, if any, comma, is done to what is that called?
My lord, the monument.
What is the name of the monument?
Ananteswar
Mahadev.
Not even spelling it properly in the cause title.
Monument. Placeway. Yes.
Item number 6.
Item 6, some time may be granted to
After
file
3
an
weeks, sir, when is it?
additional
2 weeks.
affidavit, bringing on record certain relevant documents, Your Lordship. 2 relevant documents necessary for adjudication of the matter.
Seems you have a weak case.
Keep doing it
Your
all the
Lordship,
time, relevant documents after filing the
Your Lordship, the salary of the previous
report of this stamp reporter. Let me see what that says. Stamp
Your Lordship.
reporter won't be page marked. We have to look for it now. Please call the scanning person who makes the page mark.
Yes, sir.
They think all the time. What is the stamp report? I can't understand. SR may be seen. What is that?
Adam,
Your Lordship,
statutory provision is being challenged, so you don't need any document for this.
Your Lordship, I agree, Your Lordship, that the salary of the President of District Consumer Redressal Forum is under challenge pertaining to Rule 4.2 of
That we have seen.
Your Lordship, 2 documents, additional documents are necessary, Your
What
Lordship.
document?
Your Lordship, the salary of the previous judges and the model rule basing on which our allegation, we are challenging the arbitrariness of the salary fixed.
Violation of petitioner's fundamental right.
Who are you?
Your Lordship, I am president of District Consumer Redressal Forum, Bhadrak.
You are working.
Your Lordship,
Should be removed then.
Your Lordship, may kindly grant 1 week's time.
Huh?
Your Lordship, may kindly grant 1 week's time. My senior will.
We just be granting an adjournment. We are not permitting you to file any document. We just granting adjournment. Thereafter, you do what you.
As requested on behalf of the petitioners. Does this matter on 2 weeks?
Item number 7.
Obliged.
May I plead the lordship? Some annexes are Odia Malad. I have.
Just 1 minute, ma'am. Do you hold power in this case? No.
Yes, sir. Yes, sir.
A Pradhan.
Yes, sir.
My lord, under annexer one, my lord, I have completed the work as per the work order issued.
File a money suit.
My lord,
File a money suit.
only my representation is
Representation you can pursue. The
annexer 2 is
the
my representation. That's the disposal of
application is seeking direction to the opposite parties to pay the amount to the petitioner against a contractual work already executed by him. To stop. The petitioner is said to have approached the authorities by making representation. To stop. Next. In our considered view, the present writ application seeking direction for payment of amount against the work done should not be is in the nature of petitioner seeking money claim should not be entertained. Full stop. It is, however, observed that the opposite parties shall be under obligation to pay to the petitioner the amount which is admittedly due within 3 months from admittedly due within for which the petitioner shall be at liberty to pursue the matter before appropriate authority. Application is disposed of with the aforesaid observation. What is admitted?
my representation be all directly.
Sorry, sir. Representation, you have got more than representation.
My
Item number 8. May I please, let's see. Under the public interest litigation, when a petition is the villager matters, the private party, the opposite party number 6 to 9, they acquired the Guchar land and blockage the road, one Sarva Sadharana road.
They've acquired means?
Acquired means the possession and blockage the road mile. Let's see, and the petitioner filed the under section 152 BNSS Act. Let's see, can say annexer 3 at page 23, my lord. The opposite party number.
So you have done 3 things.
Yes.
You have filed 152.
Yes, my lord.
You have taken some other step also, and third, you have filed the writ petition.
Yes.
And just let us understand. When did you file this 152?
152, let's we can say page.
When did you file? Give us the date.
Yes, my lord. Filed 11/9/2020.
11/9/2000. When did you file your representation?
My representation filed 17/8/2024.
78/2000. When did you file the writ petition?
Writ petition, my lord, filed 24/9/2024.
So why should we not impose cost?
Sorry, my lord.
Sorry. Do you understand?
Yes, ma'am.
We inquired only 3 dates.
3 dates, ma'am.
And we are convinced that cost should be imposed.
Sorry, my lord, withdraw.
Withdraw. The petitioner shall be at liberty to pursue his remedy before appropriate forum in accordance with law.
Item 9. I'm a pleasure lordships. Matters, here is a case, matters, for the recovery of the excess royalty deducted matters. That matters for years together, matters, the prisoner is running from pillar to post. Lordship may kindly have a glance. The decision of this honorable court. And the relevant person is page 15. Lordship may kindly have a look. That's the employer will work out the issue necessary computational certificate within 3 months, and within 2 months thereafter, the petitioners may.
What do you want?
Plus, the Tahsildar is not doing matters. Tahsildar, the Lordship may kindly have a glance only one. The competition part is over.
Slowly.
Matters. Competition part is over by the executive engineer, superintending engineer, way back on 17/12/2021. That is at page 39 matters, answer 3. But the Tahsildar, the next part is the Tahsildar. Tahsildar has to recommend.
Please try to understand that you are making your submission before a Chief Justice whose understanding is a bit slow. So you will have to make your submissions accordingly. Right?
Matters.
Considering the handy
Matters.
my limitation. Yes.
That you. The law says the.
What is your grievance?
My grievance is Tahsildar, the option number 3, is not recommending the amount that has been calculated by the executive engineer to the treasury for my disbursement. That is the only prayer.
Tahsildar.
Yes.
But Tahsildar said it has been refunded.
No, matters. Only two part is
23/7/2024 letter, Annexure 9 series.
Yes, matters. That is only 2 lakh something, somewhat is paid, but the rest amount is already there, and for that Tahsildar is issuing letters to the authorities, and the final authority, Lordship may kindly have a glance, page 73. Page 73, Lordship may kindly have a glance. That is the amount, the
So is the
10 lakhs.
amount is disputed.
No, computed already. It is computed, but the rest amount not paid. That is the thing.
Why?
That is, Lordship may kindly see page answer 10, page 73. That is there. State government.
Permission is
Yes, accorded, matters, but not paying till then. It is from that day also 3/9/2024. Now it is more than 2 months not paying.
Get yourself satisfied with the refundability of the amount.
File your affidavit.
My lord.
4 weeks time is allowed. Issue notice, accept notice. 4 weeks.
4 weeks time may be granted.
Yes.
Item number 10. Please, Your Lordship. Lordship, we are impugning Annexure 20 at page 95 of the Lordship brief, which is a letter dated 28/10/2024, Your Lordships.
Annexure?
20, my lord. 20, page 95 of your Lordship's brief.
Yes.
My lord, if your Lordship sees, it's a 28/10/2024 letter. My lord, we are aggrieved by serial number 2, where they have said that additional charges at the rate of 295. My lord has it? My lord, that is our grievance. Rest, everything we are fine with. My lord, what, if I may just take your Lordship 5 minutes just to brief your Lordship. My lord, this is a query, a Blackstone query which was given for auction. My lord, what happens in the auction? In the auction notice, they give you a minimum royalty. They give you a minimum additional charge. The royalty is fixed. The additional charge you bid. Now, my lord, I became the highest bidder in that auction at page 24, Annexure 2, at the rate of 122. My lord, this has already been, this was declared. I was declared. I gave the security deposit after getting, my lord, all the statutory clearances. Now, my lord, 5-year lease. My lord, this auction was for 5 years. Now, my lord, the system is they give you a demand. You pay that amount, and then they give you a lease deed for each year. Now they gave that to me. The first year was over. After the first year was over at rupees 122, while it was, my lord, going on, they gave me a first demand saying that, listen, in the meantime, we decided to increase 122 to something else. I came before your Lordship, the same petitioner came before your Lordship. Your Lordship said, pay 25%, continue with your excavation, mining, quarrying operation. Now, my lord, after the end, because that was during first year lease.
So that is pending.
That is pending. That is pending. Now, my lord, during that, my lord, after that first year lease, I gave them letter saying that as you had given me a demand for the first year, please give me a demand. I'll pay the money and I'll execute the second year lease, because, my lord, all leases has to be annual lease. Now, my lord, in reply to that, they have now further enhanced it to, my lord, what your Lordships are seeing at the impugned order, my lord. That is at 295. Your Lordship, if your Lordship sees the law,
my lord, if your lordship has the law of
Law of
mines, which is
Mines.
Odisha Minor Minerals Concession Rules 2016. May I invite your lordships to Rule 25 of the Odisha Minor Minerals Concession Rule 2016. If your lordships are holding the same book, it may be at page 39 or about.
Yes.
My lord, the heading is liability for payment of royalty, dead rent, amount for District Mineral Foundation, additional charge, etc. My lord has it?
Yes.
My lord, Rule 25, my lord, may kindly have Rule 25(9).
Yes.
The lessee, my lord, Justice Rotha has it, my lord? The lessee shall pay the additional charge for each unit quantity of mineral removed or consumed by him or his manager and employees or the contractor for the leased area at the rate finalized in the auction process, along with royalty payable to him. So, my lord, the rule says whatever has been finalized in the auction, you pay it in that amount. Now, as your lordship saw, my lord, the amount which was fixed is 122. Now, my lord, this is one. Now, my lord, may kindly also peruse 27, Rule 27, which may be at page 45. It starts at page 45. Grant of query lease.
Yeah.
My lord, may kindly see the 2 pages after. It's sub-rule 6. I'm just trying to show your lordship how the process has taken place, my lord. 6 says, the selected bidder shall be intimated by the competent authority within 7 days in Form F about the selection and terms and conditions. This has happened, and in this Form F, it has been noted that it is 122. Now, my lord, may kindly turn over the page. 13. The selected bidder shall be required to execute query lease in Form N. That has also happened for the first year in this particular case. My lord, may also see 15. The minimum amount of additional charge to be quoted shall be such as the competent authority in consultation with controlling authority decide and specify in the notice inviting applications for grant of query lease, provided that the minimum amount of additional charge so fixed should not be less than 5% of the rate of royalty.
Why do they say minimum additional charge?
Yes, my lord, because at the time of auction, they put a minimum charge that you can't go below this. That was 60 rupees, my lord. My lord, may kindly see.
No, you can't go below this, but what about higher? They've gone asked you a higher rate.
Yes, my lord. My lord, it was 60. My lord, may kindly see Annexure 1.
Okay.
Annexure 1, when they gave the notice for auction, they said 60 is the minimum.
Okay, so when you bid, it has to be above
It has to be higher.
All
so
right.
I quoted 122. They declared me the highest bidder.
Okay.
This is a case of not only, my lord, clearly in violation of the rules that I just quoted, my lord, it is also in violation of contractual terms. And then the entire process, my humble submission is then the entire process of auction is neutralized, because then you are just independently increasing it in your own whim and fancies.
And where is that matter pending?
My lord, it's pending before this honorable court. My lord, an interim order was passed in that particular case.
We'll hear both the cases.
My lord, there's a batch of matter. All the batch has the same point, my lord. One thing has been fixed. They have declared at that price, but unilaterally they have
time may be granted to file a regular counter, my lord.
How many weeks?
4 weeks time. May be granted to file a counter affidavit. We'll explain everything, my lord. For the first time it is coming, my lord.
And what about the other cases whether counter affidavits have been filed?
My lord, in cases they have counter affidavits have been filed, my lord. In some of the cases they have been filed. It's a batch of matters.
I'll inquire into it.
I'll give the batch of
I'll
matters.
inquire today, my lord.
So what is the general stand taken?
My lord, they are saying, which I've already annexed here. They say, my lord, which my lord may kindly have a glance at page 37. They say that the state government, the collector Jajpur, constituted a committee, a district level committee, who will decide. Now they have, for whatever reason, my lord, come up with, no, it will be now 295. They are replied in most of the cases, my lord, is that because the collector appointed and formed a committee, the committee told us to do it, we are doing this. Now, my lord, in reply to that, our point in those cases have been that, listen, that such kind of committee does not have a sanction of the statute.
Now, number one. Number two, you can always do it in the next auction, where in this auction you had put the minimum as 60 rupees. In the future auction, you can put it at 300 rupees. That's not a problem.
So you lease this for how many years?
For 5 years, my lord. And that's what I have been given. My lord, my difficulty today is, my lord, I have filed an IA. My lord, a similar IA in those cases have also been filed. My lord, in here, I was only pressing your lordship, my lord, in similar matters, what IA has been filed, I have also annexed it, is that while your lordships are deciding, you please execute the second year lease with the original amount of 122 and give them a demand, they will pay the money. They let them continue. The excess will be decided by your lordship. My lord, that I have also filed at flag A, my lord, your lordship may kindly see.
No, but the interim order was for you to pay 25%.
No, my lord, the distinction was 25%, and that was a standard order all throughout. Wherever, my lord, they gave an extension while my lease was pending. My lord, for example, I started in September 23. So it will end in September 24. They gave a demand in March of 24. There, your lordship said that please give 25%, continue with it. But, my lord, in cases where lease have not been executed or a second year lease was not executed and a demand of excess demand was given, there, my lord, the order was that, listen, you give them a fresh demand of the amount that you, where they became the highest bidder. The additional we will decide. My lord, may kindly have flag A. I've given such an order. But I'm only beseeching. My lord, Annexure A of your lordship, which is I.
Matter alone. We'll give them less time, 2 weeks time to file.
Yes, file counter affidavit and no interim order be passed.
We'll take up this matter.
My lord, I'll don't stand. My lord, the difficulty today is I am losing out.
2 weeks. Mr.
No, I'm not. My lord, what I'm trying to, for them, I'm only trying through your lordship, with your permission, I'm trying to address them. My lord, what is now happening is, I am the official bidder. I am not able to mine.
Other people are.
Illegal mining is continuing. State is losing out because I'm not paying any money because I'm not losing. So it's not a win situation for anyone.
All right, that you should take care of this aspect also.
Without prejudice, we can execute, but he has to pay the interest if, my lord, ultimately.
Please file your affidavit, then we will see.
My lord, fix a date, my lord.
Yes. Refer notice, submit notice. 2 weeks time is allowed to file counter.
3 weeks, kindly 3 weeks.
Two weeks. This is matter on 2 weeks within first 5 cases of opt. If no counter affidavit is filed in the meanwhile, the court shall consider passing interim orders.
Grateful, man. Deeply grateful. Item 11.
May I please, your lordship? Well, this is a tender matter, your lordship. My lord, I am challenging the illegal arbitrage of the opposite party number 2, your lordship. The opposite party number 2 invited a tender for licensing of Maxi car service in the newly Veer Surendra Sai Airport, Jharsuguda, your lordship. Where my petitioner along with other 2 have participated in the tender and applied for the tender and successfully downloaded the documents of the tender and submitted, your lordship. Thereafter, on 18/9/2024, called for a technical bid, your lordship. There in the technical bid, your lordship, I was disqualified in the reason only given that incomplete unconditional acceptance of letter in aspect to letter format, that is in Annexure C. Well, whereas your lordship may glance into.
No, your technical bid has been rejected.
Rejected.
So you have come against that.
My lord. Whereas that.
What ground you are challenging the rejection?
My lord, I'm coming.
Incomplete unconditional acceptance letter.
My lord, in the
You stated that Annexure 6, paragraph 6.
Paragraph 6.
Paragraph 5 and 6.
That is there in
Annexure 2.
Annexure page 57, your lordship.
Page 57. The rejection.
That is only a prescribed format, your lordship, that has to be done in the pad. And we have downloaded it and we have.
Where is the rejection?
57.
Page
57, your lordship.
57. 57 must be the form. Page 80 is your rejection.
Well, 80 is the rejection, your lordship. 57 is the prescribed format which has been rejected.
Incomplete unconditional acceptance letter.
That is there in 57, your lordship.
57. That must be the format.
Format. That is our format which we have submitted, Your Lordship. That is only a prescribed format which had to be
Yes,
submitted in
prescribed format. but
applicant letterhead.
Did you miss out something? Oh,
No, ma'am.
they say it is not in your letterhead, that is why it is incomplete.
No, we have given in a letterhead. Your Lordship. That is a prescribed format. Their format. You have to only
All
give.
right, all right, all right, 57. Yes.
This 57 is part of what?
So yeah, to part of tender notice, you have put that
This
inside
cannot
that.
be part of tender notice.
How?
No, this is not a tender notice, Your Lordship.
Then
This is
how
our
can you
but
put, see, what is your annexure?
One.
Annexure 1, yes. What is annexure 1?
that is a tender notice, Your Lordship.
Tender notice. And
Huh?
tender notice is from page 10 to 79.
Well, that
How
has
have
to
you
be
put this
another.
57?
That has to be done in another annex, Your Lordship. That
Exactly.
This is your bid
I
document.
apologize for that.
Exactly, that is why we are
My lord.
confused.
And where is the requirement?
So that you should have only given the format.
But for the perusal of Lordship, because we have given a present.
That would have been separate.
My lord.
No, you have submitted your bid, not the NIT. We have annexed your bid, not the NIT.
My lord, that also we have submitted in the press.
Where is
that
the
has to be submitted online, Your Lordship. We have given in the e-tender, my lord.
No, not that.
My lord.
When you say copy of tender notice, it has to be the tender notice,
My lord,
not the
that is
bid
our
you have submitted.
My lord, that is a Mr. Apology for that, Your Lordship. That is a
done.
Lordship may come to page 15.
No, we can't see anything.
So, Your Lordship, the sole parameter which has been given in the tender, Your Lordship, the general rule, Your Lordship, which is then page 15, that highest quote and over the above MRLF, which is the maximum reach of license fees, shall be the sole parameter for the selection of highest bidder, Your Lordship.
No,
And
this
we are
is
the
for-
highest bidder, Your Lordship.
Page 15.
What is page 15?
15 is the details. What he has to
Bid
give.
2, Your Lordship.
Page 15 is what?
That is the rule which for tender policies, Your Lordship. That
Yes.
is given bid 2.
Yes.
The highest quote and offer over the above the MRLF minimum reserve license fees shall be the sole parameter for the selection of the highest bidder, Your Lordship.
Yes.
And we are the only the highest.
Irrespective of whether you give the proper documents or not.
My lord, but we have, my lord, submitted with the
No, we
proper.
don't know.
Mr. Counsel, your technical bid has been cancelled
My lord.
because your acceptance of tender condition, yes, tender condition was not found to be complete. How can we say that your tender condition was complete, your acceptance was complete?
My lord, as per the.
You give that, let me get that format which is the acceptance letter. Which is supposed
My
to
lord.
give. Whether he has done that. We don't know what is that format and what he has given. He's given us his document.
It's a half a effort.
Tender thing, you have to be very particular and very careful while making your amendments, filling up the form,
It is-
everything.
Matter on 1 week, so as to enable and counsel for the petitioner to bring on record the notice inviting tender by way of affidavit.
Give
Yes.
the entire notice.
My lord, my.
Without your additions or your forms. All right. That should be the tender notice.
I am appearing on behalf of OP.
You're appearing very good. You're appearing for whom?
OP4.
Who's OP4? Airport?
Minister of Civil.
Ministry, nothing. If you are appearing for the airport, it is different.
Yes. Next.
Item 12.
Publish your lordship.
May I please your lordship? My lord, the petitioner has passed MBBS from Maharaja Krishna Chandra Gajapati Medical College. Thereafter, my lord, he applied for National Eligibility cum Entrance Test NEET PG 2024. Accordingly, my lord, admit card was granted to him under Annexure 3, where the application ID of the petitioner is PG 2400112.
PG
2400112.
Yes.
And on 11th August 2024, examination was held. Thereafter, my lord, the scorecard was given by National Board of Examination in Medical Sciences under Annexure 4, where this correct that application ID has been reflected and the rank of the petitioner is 6326. 6,326, my lord. Thereafter, my lord, the DMET, the state list of candidates, it was conducted by the Director Medical Education and Training Odisha Bhubaneswar, DMET, my lord. The Annexure 5, my lord, my application ID was reflected, wrong application ID was reflected as PG 24095,180, which is an application ID of another candidate, my lord. And therefore, my rank become 1,75,968. That's why, my lord, I have come before your lordship as a student. For my lord's kind interference in the matter and appropriate direction to the DMET so that my correct application ID and correct rank may be reflected in the state list so that I can participate in the counseling, my lord.
When is the counseling?
Counseling was from 3rd November to 6th November at Bulla.
Yes.
I, my lord, brought it to the notice of the authorities, but they did not allow me.
So what counseling will you attend now?
My lord, but the final result has not been, my lord, published. Who will take admission in which post?
Have you served copy on DMET?
State councils usually, they, my lord, Planet State Council, they usually, it is only because of a, for us, my lord,
For
human
DMET,
mistake.
Mr. Mahanti is appearing. Rajani Mahanti is appearing. We are for 1 and 2. Let my learned friend may serve a copy to Mr. Rajani Mahanti.
Today also in the
For
morning.
state, Mr.
You probably not served a copy on him. Unless he's there, how will we take instructions? Otherwise, you have to take notice, it will take a long time.
Better is serve a copy to Mr. Mahanti, Rajani Mahanti. And
Thank you. Yes.
Monday. DMET is 4. We are for 1 and 2.
Mr. Padhi, the writ petition is before us.
Yes.
But I will serve a copy, Mr. Mahanti. But that small mistake only, my lord, I have been.
Whose mistake?
We
Their
don't
mistake.
know.
DMET website mistake, my lord.
Your mistake is you not served copy on Mr. Mahanti. Every day he's present in court.
In other courts, my lord, that's why, my lord, I was on the wrong
In
impression.
other courts?
Other courts,
This
state
is the
council.
court. This is the court.
No.
For admission matters, this is the court. And DMET is represented by Mr. Mahanti.
I'll start copying, my lord, if your lordship. I will respectfully pray, my lord, if your lordship may direct the DMET to at least reflect the correct application ID and rank.
Only after you serve a copy on him and he comes here.
We don't know anything. You have said something in your writ petition that has to be seen whether that is, those statements are correct or not.
My lord, in course of the day, I will serve a copy. My lordship, I can take it Monday.
What is your roll number? What was your PG 24? Where is that reflected? 240000.
My lord, Annexure 3, my lord. Your lordship, may kindly see that is the admit card given by the National Board of Examination in Medical Sciences. Application ID.
Yes, application ID.
PG 2400112.
So it is there in Annexure 3 also, Annexure 4 also.
4 also, my lord. And the rank is, my lord.
Yes.
Where is the scorecard?
Scorecard Annexure 4, my lord. Next.
Where is the rank?
6326 XII column.
12.
Page 12.
No, serial 12. Page 13.
Yes,
Serial-
13.
Roman serial 12. Now what has it become?
My lord, after the state list of candidates, which is being conducted by the
Yes,
DMET,
yes.
my wrong application ID has been reflected under Annexure 5. My
Then
lord.
your position?
My lord, my rank become 1,75,968.
And what is this annexure 5?
Annexure 5 is the my lord, DMET website, the rank and application ID that has been published, my lords.
Where is
Extreme
it?
left, first extreme left, Anupam Misra is the ID, my lord, application ID. Wrong ID that has been mentioned, PG 24095-180. And last but one column, my lord, that is the rank, 1,75,968.
Where is your rank? Not able to find it. Page 14, where is it?
Annexure 5, my lord.
Where
Page
is it?
14, extreme left column, your lordship, my kindly.
That is the ID.
ID, my lord.
Yes.
And rank is last but one column, my lord.
Oh, acha, that was not coming in the frame. All right. Since you have given an incomplete document, you should have mentioned on top what is what. Anyway. Last is what? Your phone number? Last column?
Yes, server call.
My lord.
Tomorrow. Monday.
Monday.
My lord.
Does this case on Monday? To be taken up within first 5 cases. Let a copy of the writ application be served upon Mr. Mohanty, Land Counsel, who represents DMET. So, it is expected that Mr. Mohanty shall seek instructions in the meanwhile on the petitioner's claim as made in the writ application.
You inform Mr. Mahanti that what the court has directed.
My lord. Grateful, my lord.
Item number 13. This is a contempt, my lord. The order out of which the contempt arises is at page 12.
Page?
Page 12. It's the final order. And the relevant portions would begin from page 17, paragraph 16, 17, and 18.
So that person who had got his appointment after coming to the High Court.
Yes, my friend was. If I can show your lordships what the problem here is now. Earlier, your lordship directed in at page 17, paragraph 16, 17, and 18 that he can be considered either for 2015 or 16. Now, so far as 15 is concerned, there was an issue of eligibility. For 16, during the pendency of the writ appeal, your lordships had passed an interim order directing that you consider, state shall be under an obligation to consider his case. They considered in the interim and they said that for 16 he is eligible. That order at the interim stage, your lordship may see at flag B, annexure 6 of that affidavit at page 9. So in the interim stage, they take a stand which would be relevant for this contempt now. That my lords may kindly see annexure 6 of the affidavit at flag B. That's internal page 9 of that affidavit. That's an order dated 24/6/2024. They take note of the interim order also. That's an interim order. They have said that final order, paragraph 3. I hope my lord got that document.
Annexure 6, yes.
Annexure 6. What would be relevant would be para 3. They take note of the interim direction. 21.5 was the interim direction in this writ appeal only. And in paragraph 7 at page 10, that I would lay some emphasis on that paragraph. Whereas Sri Tripathi was acquitted in vigilance case, and as the department proceeding drawn against him has also been disposed of, the recommendation of the DPC for promotion of OSFS to OTAS cadre, which was kept in seal cover in the case of Sri Tripathi for the year 2016, was opened, and on opening of the seal cover, Sri Tripathi was found to be suitable for promotion to OTAS for the year 2016. This, my lord, may kindly take note. Now, after disposal of the writ appeal, they have passed the final order, which is at page 21. Annexure 2 of the contempt application, page 21 of the contempt. That is order dated 21/8/2024.
Yes.
Now, this is after the final order in the writ appeal. Here, your lordship may kindly see.
Paragraph 6.
Paragraph 6. For 15, it is fair enough. They find us that I am not eligible. Para 6, my lord, may kindly see at page 22. Whereas the DPC then examined whether Sri Tripathi could be considered for promotion for the year 2016. That is as on so and so, and found that the CCR's powers for preceding 5 years in respect of Sri Tripathi were not available.
Which paragraph you are reading?
Page 22, para 6.
Page 20.
My lords, I'm sorry.
Page 20.
Yes.
20
Of the
of the contempt application. Annexure 2.
Or is it the compliance affidavit? It's the compliance affidavit, page 20.
My lords, same order. Compliance affidavit also it is there, in the contempt also.
You are reading order of this court.
No,
No, my lords.
Order of the principal secretary.
Order of the principal secretary is at page 21.
21. Of the contempt application is 21.
All right.
So,
Same order.
Same order.
so that page is missing.
22, my lords, is missing.
22 is missing.
I'm so sorry, my lords. My lords, that's there in the compliance affidavit also.
I thought that scan.
Compliance affidavit.
In
it is there.
compliance affidavit is there.
It's there.
Compliance page 20.
Page 19.
Starts
That's
at
flag.
19.
Page 19, the order begins. That's flag A. Paragraph 6.
Page 19, yes.
Page 22. is not
Page
there.
19, they call for CCRs and PARs from the finance department. The problem is in page 20, paragraph 5, they deal with 2015. They say that I'm not eligible. That we accept. But the problem is in para 6. If I can place that para 6 again, whereas the DPC then examined whether Sri Tripathi could be considered for promotion for the year 2016. That is as on 1/1/2016, and found that the CCR's PARs for preceding 5 years in respect of Sri Tripathi were not available. Since it is mandatory so and so, did not find suitable for promotion for even for 2016. That means I am relegated to a stage which is worse than what they found me at the interim stage. And my lord's direction was specific. This is to circumvent the orders of this court, my lords, clearly.
How can you consider if the CCRs are not there?
No, they found the CCRs to be available with them during the interim stage just 3-4 months back. That's why I showed the interim direction earlier.
And he cannot.
And in
He cannot write his CCR.
happened is at the interim stage, they found the CCRs and all the records.
Which page is that?
That my lords is at flag B. Flag B are objection to the compliance affidavit.
Flag.
The affidavit at flag B.
Okay. Objection. Okay.
My lords. And that portion would be at internal page 9 of that affidavit at flag B, annexure 6. And the relevant portion would be para 7 at page 10, where they found me eligible for 16.
Did they say the CCRs for last years are available?
My lord, may kindly see para 7.
Para 7.
My lord, whereas Sri Tripathi was acquitted so and so, was kept in seal cover in the case of Sri Tripathi for the year 2016, was opened, and on opening of seal cover, Sri Tripathi was found suitable for promotion of OTAS cadre for year 2016. Accordingly, he has been given promotion for OTAS cadre with effect from 1/1/18. This, my lord, took note in the final order also. And my lord knows that the CCR and PAR they are the custodian of these documents. We cannot be made liable for that.
Just file your.
We'll file a response to this objection, my lord.
They have filed their compliance, but this is
Oh, you have filed.
Compliance we have filed.
Compliant.
So far as the objection to the compliance is concerned, my lord, I will seek instruction.
This is, my lords, innocuous. In fact, we have also given additional documents to show that now the records are at least with them. From the portal, we have got it. So now at least this is a ministerial act. The records are now available. During the pendency, we have found out that now the records are very much available with them.
What record?
The CCRs.
DPC has to be again.
Look, they held only because the document is not available, they didn't give us. And there was a clear direction in the final order also for 16.
Let us see the final order again.
My lords. That would be page 17. Paragraph 16, if your lordships, I can show that.
Mishra, you will have to challenge the order.
My lords, in fact, they have challenged. We have disclosed it. They have challenged it in the writ petition. That's coming up before, that's there before the single judge. But the problem is then again, I will have to.
May have to. That is the procedure.
But my lords, here, I know, my lords, that's a weakness here. But there was a specific direction, my lords. That direction is at page 17, para 18.
No, they have carried out the order. Might have been. The decision may be wrong. It is difficult.
Just because these records are not available, they are denying me.
Something is there. Sometimes everything gets delayed. His promotion got delayed. Appointment got delayed. I think appointment after 10 years. How much? Pursuant to an order of this court.
He has been acquitted.
Pursuant to an order of this court. So just little more
now before the single judge means. But the point here is that my lord said at page 18, there was a specific direction. If you find him eligible for 2015 or 16, let him be granted such promotion. 16, I'm eligible. But
we have understood, but can we compel the DPC if they don't have the documents to pass that order?
Just to bring a closure to this, what I was humbly submitting, we are willing to forego 15. There's a case for relaxation, but that we are not pressing. For 16 only, my lords, the records are now available. Let them see if it, because
Contempt will direct that they will again hold the DPC.
No, but my lords, this is to circumvent. There's a clear direction to this. The approach of theirs is to circumvent the orders.
All the officers sitting in the DPC are trying to circumvent. I can understand one person or somebody who's trying to do it.
Knows how that works.
The petitioner in the present contempt application has alleged disobedience of this court's order stated so and so, paragraph 18 of which reads as under. In compliance of the said order, DPC was convened. Stop. The petitioner has, however, been denied consideration for promotion for 2016 DPC on the ground that he was not eligible for such consideration in the absence of CCRs
Last 5 years.
for the last 5 years. So stop. And a compliance affidavit has been filed in this case. Stop. With an additional affidavit we filed stating whether absence of CCR can be a ground for holding an employee ineligible for promotion. Correct. Do it.
2 weeks.
2 weeks.
Or 3 weeks.
3 weeks or
3 weeks.
A grateful team. Item 14.
May I please, my lords? My lord, the non-compliance of the order dated 23/4/2024, I have filed this present content petition, my lord. After receiving the order from this honorable court and also from the petitioner.
Where is the order?
My lord, I have quoted, starts from page 3 of my content petition.
And ends?
Hence, the state authorities have already written a letter to the opposite party, party number 2 and 3, to comply this order to avoid the contempt proceeding, but they have not taken any action. In the meantime, 7 months has already been passed.
So what is the order?
Order, my lord, starts from 3. May I read, my lord?
Starts from page 3.
Page 3 of my
Annexure
content.
3.
My lord.
Annexure 3.
Annexure 3 is the, in terms of that Annexure 3, my writ application has been disposed of by this Honorable High Court. My prayer in my writ application, my lord, for engagement under Rehabilitation and Resettlement Policy 2006, because I am the land trustee. The whole objection of the authorities are the since I have purchased the land in the year 2010, which is 1 year prior to the 4-1 notification, I am not eligible. But that issue has been decided in the Gosibananda Naik's case under Annexure 3, that is prospective, that is not retrospective. That is why this Honorable Court has been pleased to dispose of my writ application in terms of that Gosibananda Naik's case, my lord.
We have not been able to understand anything. I'll your so cause.
My lord. My lord, your lordship may kind have a glance that Annexure 2 series.
All right, we'll see later.
My lord.
So you have not given the order on which you have not given the order on which you rely, disposing of your writ application.
Yes, that is the Annexure 3.
Annexure?
Annexure 3 they have. They have to examine and file also.
This case court has relied upon?
That Annexure 3.
That Gosibananda they have.
Gosibananda Naik's case, that is the.
Are you Gosibananda?
My lord.
Are you Goshivananda?
No, no.
Then
I am the petitioner in WPC number 14,457 of 2000.
yeah, so where is that order?
That is quoted in page 3.
Quoted.
My lord. That is quoted.
Honorable Court directed that in the terms of Goshivananda, his case should be considered. We will file our SOPAJ explaining what happened, my lord.
Yes.
Why his case could not be considered yet. 4 weeks,
Yes.
4 weeks may be granted.
No, 4 weeks.
Let's say fix a date.
You get that.
For admission item number 25.
4 weeks. No? 4 weeks. 12.
Item 25.
I am for the respondent, my lord. State is the appellant, my lord, here in the writ appeal, my lord.
Issue notice in that
Only state, no. Other opposite parties.
other opposite party is the MCL manner.
Notice was issued.
That content.
Huh?
That one which he was doing from this side, now he's gone.
Sorry, I beg
It's
pardon.
all right, that is very good.
Which matter?
That last one, that.
Last one, content petition, my lord. Item 14.
Notice is to go.
Because there's a MCL private party.
Issue notice gets
Requisite by Monday, man.
Monday.
Then why have you made the
State authorities as parties.
as an opposite party?
As the land acquired by the state, my lord. State is
Then let the state get instruction.
yes, my lord. State instruction and that policy decision has been taken by the state.
Also, then let them get the instruction. Thereafter,
Yes, ma'am.
we'll consider issuing notice.
Yes.
Annex.
Yes.
For admission item 25.
I am for the respondent in this case, my lord. State is the appellant, my lord.
Purchase item, not purchase.
Yes, where is the order?
So 5, at page 21 to 25, my lord. Which is passed to the honorable single judge. That is challenged by the state authority.
Anisha 5.
Much obliged. Calling for some permission, my lord, at page 25. May I please?
First day. Or not first day. Terminal matter.
Yes.
Respondent has relied on the judgments rendered by the Honorable Supreme Court and sought for regularization. The Honorable Single Judge, relying on those judgments, have directed for regularization. But our stand is, my lord, his appointment was not a continuous one, not against a regular post, vacancies were not available, and he was not fulfilling the eligibility criteria as per the recruitment rule. Those things were not taken into consideration, only relying on the judgment rendered in Rajendra Kumar Naik's case. The petitioner has been held to be eligible to be absorbed. In para F,
Where are you pointing out? What should we look at?
page 7 of the writ appeal.
7.
Grounds we have taken in we have stated as to how the judgment rendered in the case of Uma Devi, so also ML Kesari, are not applicable to the case of the respondent because he was not appointed against the post. He was a casual worker, ML employee. That is why, in terms of para 44 of that Uma Devi judgment, it has not got a straight application to the case of the respondent.
So what was the material before the learned single judge to hold that the respondent was continuing regularly from 1997?
That is only on the submission, my lord, of the respondent. But
Paragraph 6, there's a reference to an earlier order where the tribunal has directed that he may be allowed to continue until regular recruitment is done.
that is how we.
That means he must have prayed for absorption there also.
There also, but it has not been, no absorption order has been passed.
Can't be because this is just allowing him to continue till regular appointment.
Yes, ma'am.
So that means he's continuing by virtue of the order of
the court. So that is also, that is a bar. The Honorable Supreme Court has said, while somebody has continued for more than 10 years without being protected by any order.
Yes, what is your submission?
Well, made by the State Council, perhaps they have not verified to that extent. I kindly, first of all, to see page 14 of their writ appeal, Annex 1, my lord. Got it, my lord?
Yes.
May I please, my lord?
Yes. Yes.
Prior to that, just I'm giving the history.
Page 14.
I date chapter.
Page 14. 27. Listing vacancy.
What is MFD?
FMD.
Fieldman demonstrator, my lord.
What is the date?
My lord, we kindly see 26/8/97, my lord. The order of the past.
Annexure, page 14.
Page 15, my lord. Continuation.
Yes.
Then thereafter, Annex 2, my lord. Page 16, my lord. The order of the past by sub conservation officer, my lord.
Yes.
Then thereafter, I took the shelter of the Honorable Tribunal. Page 17, my lord. Page 17, Annex 3.
Where is this? 26/9/2002. As per later dated so and so of Directors Fire Conservation, Odisha, Bhubaneswar.
26.
26/3 or 26/2, whatever it is. Annexure 2.
Annexure 2.
As per later date.
As per letter number 1 so dated 26/3/2002, Director of Soil Conservation, Odisha, Bhubaneswar, terminated with effect from 31st March 2002 afternoon. Then thereafter I took this.
Mr. Where is
What
this
was that
letter?
Letter.
Why was it terminated? Regular appointment was to be made or what?
No, that
I don't
letter
know.
no, made my letter.
So that
Because
is
this is the termination letter.
that is the central point.
Yes,
That is the central point.
yes, but that is the termination letter, my letter.
No, that is not the termination letter.
Basing
That
on-
is just communication.
Yes, communicate that letter, I will correct, madam. That letter I
Corrected then what?
correct.
If this letter was not considered, then where was the question of any consideration?
With permission to that extent, so far as after the direction of the tribunal, with your permission, my lord, as per annexure 3, page 17, my lord, relevant portion may I place with your permission, my lord.
Please.
Yes, my lord. In the para 4, my lord, at page 19, my lord, the relevant portion. In conspectus of the facts and circumstances, we feel that the ends of justice would be met if the applicant is allowed to compete along with others eligible for appointment to the post of FMD, field administrator, for which regular vacancy exists, because you have to continue first annexure 1 existing vacancies. He would not be debarred for age and he would be granted the concessions of the age from the date of his first appointment as FMD until the date of advertisement for recruitment to the post of a regular basis. The applicant will continue in the post he is holding until he is thus considered for recruitment.
So you are not recruited?
No,
It is clear.
Yes, ma'am. Highly obliged to that extent. For that reason, with the lordship's permission to that extent, I want the number of directions which are given my lord justice is there. And after that, my lord, some of the persons which are kind.
Some of the persons what?
These are the decisions which have been passed by this honorable, also this honorable Supreme Court of India, in respect to the employees of the self-same department. Because their services were terminated, they took the shelter of the honorable tribunal. Honorable tribunal allowed them. The government took the shelter of this honorable High Court. High Court confirmed the order of the honorable tribunal, and thereafter they went to the Supreme Court. Honorable Supreme Court also confirmed the order of the tribunal. So, in response to the same, the persons who are junior and also the subsequent terminated, they have been allowed to continue regular basis. My Lord Justice is there. So I have also given that this number of decisions I have imposed. Permission. May I place my Lord? I was also arguing this self-same case, which will at page 2, and the persons have been regularized before this honorable court, my lord. I have the counsel for those petitioners. And out of them, one of the person was junior, my lord. I have also reflected in page 7, my lord. They are the ad hoc employees. They are
All right, please examine these decisions
Yes,
and address.
they
to 10 minutes, my lord.
Can they not email?
They have not.
Physically he will bring.
Physically he will bring, my lord. Only I 2:30.
Yes.
Just now talk within 10 minutes they are reaching.
Pandagiri.
Just a minute. No. Prism.
Prison one will take now. Oh, prison one will come. Sorry. Prison one. Sorry.
Prison Directorate and NIC.
Learned ATA. Based on instructions, referring to this court's order dated 13/11/2000 24 has submitted that a meeting has been held today with the
NIC authorities, NIC officials.
today with the NIC officials. Full stop. The outcome of the said meeting is not known to him. Full stop. List this matter 1 week. Full stop. In the meanwhile, the an affidavit shall be required to be filed on behalf of the IG Prisons stating further development.
Yes.
That's all.
And I'll serve a copy on the London amicus curiae so that Lordship may fix up.
By 1 week, date the house contains the list.
Yes.
File your affidavit by 20th.
20th.
The matter will come on 21st.
Grateful, man, grateful.
Since all parties are there in 35 Miller, all parties are there. I am one of the parties, Miller. Which I have to serve the copy of the counter.
Let that be called.
Item 26.
My lord, pass over this matter. Pass over.
Pass over, right?
My senior counsel is another.
Call him.
To this matter as requested.
On Tuesday. Good way of thinking.
Is there any interim order?
What is the case? What is the case about? Mr. Counsel, what is the case about?
My lord,
What is the case about?
my lord, in this case, I am not in power, my lord.
Then? You need not have the power. You are not attached to Mr. Joshi's office.
No.
Come to court then. Why are you in this court?
He will inform me.
No, why are you in this court? Are you waiting for any other case?
No.
Then?
He said me pass over this matter.
You've been asked to get instructions.
Man.
You had, Mr. Joshi had taken time in 2023 to file rejoinder.
My lord.
Yes.
I'm not instructed, my lord. He only said pass over this matter.
And it has come up on mention. Mention of whom? Mention memo. IA for appropriate orders. Mr. Joshi has filed the memo and the IA.
When?
This memo had been filed on 4/10/2024.
This matter has been listed on a mention having been made on behalf of the petitioner. Stop. Upon call, an adjournment is being sought. Stop. List this matter. 8 weeks. Yes.
Item 27.
Tender matter.
Item 20. Is there any no interim order?
No.
We make it clear. We make it clear that pendency of the present writ application shall not come in the way of the tendering authority or any other authority taking appropriate steps. Yes.
27.
Item 27, Your Lordship, on behalf of Dr. J.K. Lenka.
Your Lordship, it's the second contempt matter, Your Lordship. Non-compliance of order dated 4/4/2023 at Annexure 1, page 8, Your Lordship.
Not a typical.
Relevant portion, Your Lordship, page 13.
इंश्योरेंस एक्ट निकालो इंश्योरेंस एक्ट है हमारे पास 1938 नहीं है ना
The 9th para of the order has not been implemented, Your Lordship. However, the 10th para has been implemented.
Tenth has been implemented. Subsistence allowance has not been paid.
Lordship, I'm filing an affidavit.
Not
The
paid.
principal has already forwarded the bill for paying substance allowance since March.
Bill?
Yes, Your Lordship. March 24. Since March 24, they have already given.
I am appearing for the principal. I have already sent the bill to the director for sanction and release.
Subsistence allowance due to the appellant will be paid to him.
Since 16th March 2024. 16th March.
The direction was to whom?
Direction was to all the respondents.
There was no direction to all the respondents. The direction was just
Appearing for the respondents assures. The court that substance allowance due to the appellant will be paid.
Second attempt.
Your Lordship.
And where is the first order?
From the original
Order passed in the first case, first contempt.
Contempt he has put it. Running page 52.
Lordship, Annexure 6, page 18, Your Lordship.
Okay, you have also annexed it. Order they're giving, not giving the case number. Whatever.
Annexure 6, page 18.
Lordship, relevant page 20.
Page 20.
The initial order was to file a representation.
No.
Yes, because
No, in the honorable single bench, Your Lordship, there was initial order was
single judge had directed for.
Lordship. Then in writ appeal, Your Lordship, we came before this honorable court. This honorable court quashed the suspension order and directed for paying of substance allowance, Your Lordship.
So have you filed your so-called reply?
I have made ready. I will be filing within 2 days. I have the document that I have. He has also annexed to the present affidavit. I have sent the bill to the director for sanction and release since 16/3/2004. 24.
Petitioner in the present contempt application has alleged disobedience of this court's order dated 4/4/2023 to the extent the same relates to payment of subsistence allowance to the petitioner during the period he was under suspension. Stop. Relevant paragraph 9 of the said order reads thus. Stop. Mr. So-and-so appears on behalf of the governing body of the college.
I am for the principal.
For
OP
the
number 3.
Principal of the college has submitted that necessary bill for payment of subsistence allowance to the petitioner has been sent to. So give us the letter. The Director, Higher Secondary Education Department, Odisha, on 16/3/2024, he submits that despite that the amount has not been released
Yes.
by the Director, also for payment to the petitioner. First off, it has been accordingly submitted that the principal of the college has carried out the court's order, but it is because of the failure on the part of the Director, Higher Education,
Higher secondary.
Education, that the order has not been complied with. Stop. Next, this is second contempt application filed by the petitioner alleging violation of the same order. Stop. The petitioner had earlier approached this court by filing contempt petition giving rise to CONTC number 3476 of 2023, which was disposed of granting liberty to the opposite parties to comply with the order if the same was not already complied with. Stop. Next, considering the circumstance that despite repeated orders, this court's order has not been complied with. So, in such view of the matter, we are of the prima facie view that a gross case of contempt of court is made out. Stop. Let the directors
Higher secondary
education, Government of Odisha, be personally present in court on next Thursday with an explanation as to why contempt proceeding be not initiated, why charge be not framed against him for intentional violation of this court's order, and he be not punished appropriately for the same. Yes. Next Thursday, 10:30.
My lord, it is
Tell him.
27.
Item 27.
Item 27, my lord.
Yes. Ask him to be here.
28.
My lord, may I submit, my lord, review petition is pending. That is the only submission.
Review? Why didn't you say?
My lord, review petition is pending, my lord.
Why review is pending?
In affidavit, we have mentioned the number. At page, my lord, in our SOCOS affidavit.
Lots of copy notes of that SOCOS affidavit copy is not.
Review petition number 385 by 2023. And that is
not given a copy of the SOCOS.
SOCOS by OP2 or OP1, 3 and 4?
OP2, my lord.
Okay.
OP2. The state has gone in review, my lord. Copy I am right now serving me. He filed on 10/4/2024. Right now I am copy serving.
Where is the review application?
Review application is not before your lordship, my lord. Review application is filed. That is the affidavit 385 by 2023.
Petitioner has alleged disobedience of an order of this court dated 4/4/2021, WA number
1608 by
2022, Stop. Yes, from the so-called affidavit filed on behalf of the opposite party number 2, that a review application has been filed seeking review of the said order while RVWPET number 385 of 2023. The stop list this matter on Thursday has been dismissed.
Has been dismissed. Have you challenged that order passed in review?
My lord.
On the ground of delay, the review has been dismissed.
I have no information, my lord. I will check up, my lord. 1 week time may be granted, my lord. 1 week time, I will come with.
This is very serious matter.
No, my lord, I will ensure.
When the matter was called, you did not respond. After we dictated the order, you are saying that you are appealing for the.
Extremely sorry, my lord. I'm extremely sorry.
And then you are saying review application has been filed. You don't know the review application has been dismissed.
If the review application is dismissed, my lord, I will ensure compliance by the next date, my lord.
On behalf of the.
Don't make submissions without proper instructions.
My lord, because I will. My lord.
28.
Kind attention, my lords. I am appearing for the appellant.
Yes.
I have already concluded my submissions on the last date of hearing.
Yes.
Here, the point involved here is regarding interpretation of section 39 of the Insurance Act 1938, which was amended, my lords, with effect from 26/12/2014. It was a retrospective amendment. Now, what my learned friend for the appellant has been saying, he has a point, my lords. I must concede right away that the Honorable Single Judge has not dealt with the development, the amendment, and the judgments against me would be the Delhi High Court judgment, if your lordship would recollect, and there would be the Madras High Court judgment.
And the statute also.
And the statute on its face value. To make matters worse for me, my lords, the Delhi High Court judgment was carried to the Supreme Court, and SLP against that was also dismissed. So, of course, I stand with the -10 here because of that dismissal. But then I have a point, my lords. I have made a short note also for that. I'll quickly show the Law Commission report which led to that amendment. Because in my favor, my lord, there's also a Karnataka High Court judgment. So we have High Court judgments of Karnataka, Guwahati, so many other High Courts, which are in my favor. There are some judgments in his favor. Now, let me begin with this Law Commission report. If your lordship would see clause, may I just recapitulate the amendment, or I'll straight away come. My lord recollects the amendment. Beneficial nominees have been introduced pursuant to the Law Commission's report. Now, my lord may see the why I am saying so, because the Law Commission not only made a number of recommendations, the Law Commission also gave a model section. But what thereafter happened, all these recommendations were not carried. So I'll just show some of the recommendations first. Clause 7.1.2. I hope I have given hard copies. Another area which required clarification was that of a beneficial nominee as distinguished from a collector nominee.
Yes.
Under section 38(6), where a nominee survives the insured person, the policy money would be payable to such nominee survivor. The question then arises whether this payment to the nominee is to the exclusion of the legal representatives and heirs or even creditors who may have a legitimate claim against the estate of the deceased, of which the money payable on maturity of the life insurance policy forms part. Then your lordship may skip 7.1.3 and come to 7.1.4. That is at page 77 towards the bottom. 7.1.4. The government did not act upon the aforesaid recommendation. Meanwhile, in 1984, the Supreme Court in Sarbati Devi so-and-so 1984 SC 346 held that the provisions of Section 39 would not alter the position of succession under the law. It was clarified that a mere nomination under Section 39 does not have the effect of conferring on the nominee any beneficial interest in the amount payable under the policy on the death of the assured. The court further observed that the nominee acquires no interest in the policy during the lifetime of the policyholder. Therefore, after the death of the policyholder, the amount under the policy becomes payable to the legal heirs. The nominee is only the authorized person to collect the payment so that the insurer gets a valid discharge of its liability under the policy. 7.1.5. The decision in Sarbati Devi prompted the Law Commission to modify its earlier view while dealing with nomination in regard to Provident Fund. In its 137th report on the need for creating Office of Ombudsman for evolving legislative administrative measures inter alia to relieve hardships caused by inordinate delays in settling Provident Fund claims of beneficiaries 1990, the Commission recommended that a statutory provision be made to the effect that the amount payable will vest in the nominee, who will be called the beneficiary nominee, unless the policyholder names some person as a collector nominee for the purpose of collecting the amount on behalf of the legal representatives of the deceased policyholder. In other words, an option would be made available to the policyholder to express in clear terms whether the nominee concerned is a beneficial nominee or a collector nominee. So this is the crux of the recommendation, and this was not acted upon. When the provision has now come about, it's only the beneficial nominee who has been listed, and there is a deeming clause that if you don't mention it, it automatically goes to the beneficial nominee. So this collector nominee concept is not there in spite of the recommendation. Now, your lordship may just see, this is of course to persuade your lordships, and there is also a Supreme Court judgment, which I'll come to that, at page 79, 7.1.9. Page 79. This is something interesting what the PSUs have suggested, PSU insurance companies. Om Kotak points out that there's a need for clarification in regard to the concept of absolute nominee. They also suggest that there should be a full discharge of the insurer once the amount is paid to the nominee. Next line, my lord, is important. The National Insurance Academy has suggested that the law be made clear that the nominee does not have ownership rights to money. This suggestion has also been concurred with by HDFC. The government of West Bengal has suggested that the provision be amended to bring out the distinction between collector nominee and beneficial nominee. Life Insurance Corporation has recommended that Section 39 be retained as it is. Then, my lords, may kindly see the Law Commission's views. And then the final recommendations. I'll only place the relevant portion, that would be 7.1.14 at page 80. After considering all the responses and re-examining the entire issue, the final recommendations of the Law Commission regard to Section 39 may be summarized as under. A clear distinction be made in the provision itself between a beneficial nominee and a collector nominee. B, this is very important, my lords. It is not possible to agree to the suggestion made by some of the insurers that in all cases, the payment to the nominee would tantamount to a full discharge of the insurer's liability under the policy, and that unless the contrary is expressed, the nominee would be the beneficial nominee. Now, the Law Commission is the specific instruction that this is not possible to agree. But if your lordship analyzes what has now come in the section, it is precisely this. And the interpretation that is now being pushed is contrary to this recommendation.
No, in fact, it appears that the Law Commission's recommendations have not been accepted in toto.
In total. Some of them have been accepted, but what I was, of course, I can't argue that because the statute has come in. I am conscious of that. But your lordships, in the course of my submissions, I'll show why this would be relevant. So your lordship may just keep this in mind. This B is something important.
Right.
Then C, an option be given to the policy holder. This C is also important in the context of what I'll say in the next 10 minutes. An option be given to the policy holder to clearly express of the legal representative. In other words, such nominee will be the collector nominee, or whether the nominee will be the absolute owner of the monies in which such nominee will be the beneficial nominee.
Yes.
And if my lord would see they have formulated a section itself. The suggested amendment begins from page 81, and the relevant clause would be at page 83, clause 11, which is missing. Clause 11, every policyholder shall have an option to indicate in clear terms whether the person or persons being nominated by the policyholder is our beneficiary nominee or a collector.
So therefore, C was not accepted. 7.1.14.
My lord.
That was that recommendation of the Law Commission was not accepted.
My lord. B was also not accepted.
And B was and C is very close to this 11.
My lord. No, in fact, if I can say, my lords, A, B, and C, all three were not accepted.
Not accepted.
So what I'm trying to show, my lords, to persuade your lordship, is that this was the crux of the recommendation of the Law Commission, and this has to be seen in the context of what the PSU had also said. The PSUs, National Insurance and HDFC, one of the leading insurance players, they had said that nominee should not have absolute ownership of the money. Now, in this context,
Mr. Mishra, we cannot read the provisions of the statute with the recommendations of the law.
My lords, I completely.
We will have to read the statute as they are.
My lords, I bow down to that. I'm just trying to.
Yes.
Bring something to your lordship's notice. Your lordship may just see the note. This is a very short note to make it easier for your lordship. My friend's associate, if he's here, I can give it. Otherwise, we'll try to send it on.
What?
To send it to him, the local council would have been there, so he said I would have served copy.
Yes.
My lords. Now, this contains all my broad points, my lords. My lord may just see there is one judgment of the Honorable Supreme Court, which I had shown to your lordships. That would be 2024 4 SCC 642.
Yes.
Now, I'll show this judgment right away. Now, what I'm trying to say, my lords, I'll just summarize what I'm trying to say. This judgment makes a passing reference to section 39, approves Sarbati Devi, and goes on to interpret Section 109 capital A of the Companies Act, which is pari materia to Section 72 of the Companies Act 2013. Now, the text of those two provisions is even more stringent than this provision. So while interpreting that, the Honorable Supreme Court says that no, this in view of this provision also, the nominee is not the absolute holder of the property. So I'm trying to rely on this judgment to show that even a more stringent provision has been held in favor of the law of succession.
Yes.
And till the Honorable Supreme Court changes its view in Shakti Yazdani, that would be the law which would govern the field as on date. So if I may say, just in my note, I have said that on 26/12/2014, the amendment came about to Section 39 of the Insurance Act.
Yes.
On 14/12/2023, that is almost 9 years, the Supreme Court gives this judgment. Now, my lord may see the portions of the judgment, because this is the strongest point in my favor. So I'll rely on this judgment first. We have given hard copies of that judgment.
Yes, we do have.
Now, my lord may just see the judgment is dated 14th December 2023.
Yes.
On the first page. Now, if your lordships would see the relevant portions.
Yes.
Let's take para 39, my lords. Para 39 at page 660, my lords. In fact, while interpreting other enactments that are similar in nature by virtue of the fact that the provision of nomination within the statute begins with a non-obstante clause and or is armed with the term vest, such as the Banking Regulations Act, the Government Savings Certificate Act, and the Employees Provident Fund Act and the Miscellaneous Provisions Act, multiple courts have rejected the argument that the nominee would become the absolute owner to the exclusion of the legal heirs. To hold otherwise would, in our opinion, exceed the scope and extent of Section 109 capital A of the Companies Act 1956. Then, after that, nomination under various legislations. In an illuminating list of precedents, this court, as well as several high courts, have dealt with the concept of nomination under the legislations like the Government Savings Certificate Act 1959, the Banking Regulation Act 1949, the Life Insurance Act 1939, Qua Re Insurance Act 1938, and the Employees Provident Fund Miscellaneous Provisions Act 1952. It would be apposite to refer to what the court said on the nomination in reference to these legislations. Then they have given a table.
Yes.
Now, what would be relevant in the context of this case would be Sarbati Devi and nomination under 39 of the Insurance Act 1938 is subject to the claim of the heirs as assured under the law of succession.
Yes.
Then para 41, a consistent view appears to have been taken by the courts while interpreting the related provisions of nomination under different statutes. It is clear from the referred judgments that the nomination so made would not lead to the nominee attaining absolute title over the subject property for which such nomination was made. In other words, the usual mode of succession is not to be impacted by such nomination. The legal heirs, therefore, have not been excluded by virtue of nomination. Now, before I proceed to para 42, your lordship may just take up section 109 capital A of the Companies Act 1950. Because that was the provision which fell for interpretation. Probably that book doesn't have 1956. It has 2013. Otherwise, I'll place 70. The similar provision is 72 of the 2013. For convenience, we have quoted it in all the provisions in the note.
Yes.
If your lordship wants to refer to the note, we'll read it from the note. But the note, I have highlighted those words. I'm sorry for that, but that's for
It's all right. Yes.
laying emphasis to that provision. Now, let me begin with 109 capital A, or from the book I'm reading, my lords, of the Companies Act. Every holder of shares in or holder of debentures of a company may at any time nominate in the prescribed manner a person to whom his shares or debentures of the company shall vest. So my lord may take note of this word vest in the event of his death. Then clause 2, your lordship may skip. Your lordship may come to clause 3.
Yes.
Notwithstanding, in the new book, it would be section 72.
Yes, please read.
Well, clause 3 begins with notwithstanding anything contained in any other law for the time being in force or in any disposition, whether testamentary or otherwise, in respect of such shares in or debentures of the company, where a nomination made in the prescribed manner purports to confer on any person the right to vest the shares in or debentures of the company, the nominee shall, on the death of the shareholder or holders of debentures of the company, or as the case may be, on the death of the joint holders, become entitled to all the rights in the shares or debentures of the company, as the case may be, to all the joint holders in relation to such shares or in debentures to the company, to the exclusion of all other persons, unless the nomination is varied or cancelled in the prescribed manner. I lay emphasis on these words: vest, notwithstanding any testamentary disposition, and to the exclusion of all other persons. Now, in spite of this kind of language, my lords, the Honorable Supreme Court still says that the law laid down by Sarbati Devi is good law, and this will not come in the way of law of succession. Now, if we compare 109 capital A with 39(7), then the language used in 109 capital A is even more stringent, because 39 doesn't have these expressions. So that's the point I'm trying to make, my lords. Now, if I come back to para 42 of Shakti Yazdani,
yes,
they have analyzed all of this, and then they have said at para 42, the presence of three elements, that is the term vest, the provision excluding others, as well as a non-obstant clause under section 109 capital A of the Companies Act, have not persuaded us in the interpretation to be accorded vis-a-vis nomination in any different manner. Different legislations with provisions pertaining to nomination that have been a subject of adjudication earlier before courts have little or no similarity with respect to the language used or the provisions contained therein. While the Government Savings Certificate Act 1959, the Banking Regulation Act 1949, and the Public Debts Act contain a non-obstante clause, the Insurance Act 1939 and the Cooperative Society do not.
Yes.
Similarly, there are variations with respect to the word vest being made present in so and so are absent in legislation, the Insurance Act, Cooperative, looking at dissimilarities. So ultimately, they analyze this, and in paragraph 44, they go on to say that the legislative intent of creating a scheme of nomination under the Companies Act 1956, in our opinion, is not intended to grant absolute rights of ownership in favor of the nominee merely because the provision contains three elements. That is vest, a non-obstante clause, and the phrase to the exclusion of others. Now, this phrase to the exclusion of others has also been italicized, which are absent in other legislations that also provide for knowledge.
Yes.
Then the other relevant paragraphs would be para 57. The appellants have contended that the nominations under section 109 capital A of the Companies Act and bylaw 9.11 of the Depositories Act 1996 suggest the intention of the shareholder to bequeath the shares, securities absolutely to the nominee to the exclusion of any other persons, including legal representative, and constitutes a statutory testament. However, aforesaid argument is not acceptable for the following reasons. I'm reading from para 57.
Yes.
Companies Act 1956 does not contemplate a statutory testament that stands over and above the laws of succession. So this same analogy may apply to the Insurance Act. The Companies Act 1956 is iterated above, is concerned with regulating the affairs of corporates and is not concerned with the laws of succession. The statutory testament by way of nomination is not subject to the same rigors as is applicable to the formation and validity of a will under the succession laws, for instance, section 63 of the Indian Succession Act, wherein the rules for execution of will are laid out. Therefore, the argument by the appellants of nomination as a statutory testament cannot be countenanced simply because the Companies Act 1956 does not deal with succession, nor does it override the laws of succession. It is beyond the scope of the company's affairs to facilitate succession planning of the shareholder. In case of a will, it is upon the administrator or executor under the Succession Act 1925, and in case of interstate succession, the laws of succession to determine the line of succession. Conclusion. Consistent interpretation is given by the courts on the question of nomination, that is, upon the holder's death, the nominee would not get an absolute title to the subject matter of nomination, and those would apply to the Companies Act 1956, pari materia provisions in Companies Act 2013, and the Depositories Act 1996 as well. An individual dealing with estate planning or succession laws understands nomination to take effect in a particular manner and expects the implication to be no different for devolution of securities per se. Therefore, an interpretation otherwise would inevitably lead to confusion and possibly complexities in the succession process, something that ought to be eschewed.
Yes.
Another paragraph, Your Lordship may kindly take note. Para 63. Additionally, there is a complex layer of commercial considerations that are to be taken into account while dealing with the issue of nomination pertaining to companies, or until legal heirs are able to sufficiently establish their right of succession to the company. Therefore, offering a discharge to the entity once the nominee is in picture is quite distinct from granting ownership of securities to nominees instead of the legal heirs. Nomination process, therefore, does not override the succession laws. Simply said, there is no third mode of succession that the scheme of the Companies Act 1956, pari materia provisions in so and so, aims or intends to provide. Now, since I'm trying to show everything to Your Lordship, points against us, there is one Supreme Court judgment which takes a contrary view, but which has not been noticed here. That also I'm showing you. Aruna goes.
Will you please repeat the name of the judgment, please?
Reported in 2020, 8 SCC 79.
Name?
Aruna Oswal.
Aruna Aruna Oswal versus Pankaj Oswal.
Please, please.
Yes.
It's here. What would be relevant would be when this matter was adjudicated in 2020, in paragraph 18. Paragraph 18 would be important. I'm sorry, my lords. Aruna Oswal, the relevant paragraphs would be para 10. First, your lordship may see paragraph 10.
Yes.
In paragraph 10, what I'm trying to show your lordships is that the Supreme Court takes note that this Shakti Yazdani case is pending. Paragraph 10, they mention that Shakti Yazdani is pending. Towards the bottom, my lord may see, I'm reading that portion. The matter of inheritance is pending adjudication before this court in another CA, number 7107 of 2017. I hope my lord gets that. Page 86, paragraph 10,
yes,
towards the end. And then as a passing observation, they mention in paragraph 18. Paragraph 18, this would be against me. The learned senior counsel has also placed reliance on Sarbati Devi versus Usha Devi, in which the question came up for consideration regarding section 39 of the Life Insurance Act 1938 concerning rights of a nominee in the amount covered under the policy when the assured died intestate. It was held that nomination was subject to a claim of
you
the
are reading
heirs.
which paragraph?
Paragraph 18 at page 92 on the left hand side.
Page 92. Yes. Yes.
The learned senior counsel has also placed reliance on Sarbati Devi versus Usha Devi, in which the question came up for consideration regarding section 39 of the Life Insurance Act concerning rights of a nominee in the amount covered under policy when the assured died intestate. It was held that nomination was subject to a claim of the heirs of the assured under the law of succession. The provisions of section 39 of the Life Insurance Act 1938 are quite different from the provisions contained in section 72 of the Act. The rights of the nominee would depend upon what is provided statutorily. There was no vesting of interest provided in the nominee under section 39 of the 1938 Act. Hence, the decision does not espouse the cause of the Act.
Yes.
So this view, these passing observations in Aruna Oswal have somehow not been taken note of in Shakti Yazd. But what I'm trying to make out, if I may come back to my 6-page note, I'll just stick to the note from here on. What I'm trying to make out before your lordships is that till the judgment in Shakti Yazdani is modified by the Honorable Supreme Court, that would be the law governing the courts. That is my first point. Then I just made the other point that section 109 capital A of the Companies Act is a most stringent provision.
Yes.
And at page 2 of my note, I have underlined those portions.
Yes.
Which show that a more stringent provision has been interpreted to hold that the law of succession will prevail.
Yes.
Then at page 3, I have, towards the bottom, my lords, I have made a point that obiter regarding section 39 of the Insurance Act is also available in Shakti Yazdani. So this obiter also would bind the High Courts. That obiter I place, my lord, Sarbati Devi is approved. In that table, they approve it. And it can't be presumed, that point also I have mentioned, my lords, at page 4. Page 4.
No, but this Sarbati is pre-amendment.
Sarbati is 1984. That is pre-amendment.
So that has been taken note of. Pre-amendment.
My lords. In fact, what I am trying to make out would be at page 4, point number 6. The Supreme Court recently has tried to bring in this expression that when a provision in the statute tries to take effect with the effect of a judgment, then they say that it is legislatively over. No such expression has been used in Shakti as that. The judgment comes about in December 2023, 9 years after the amendment. But they never say that Sarbati Devi is no longer valid, or in view of this amendment, Sarbati Devi is no longer to be followed. Those things are all absent. While in other judgments, they use these expressions. Now, I have to say, this.
Sarbati is to be followed.
My lords.
Sarbati was a good law, and Sarbati is still a good law.
My lords.
It is because of the amendment in 39 that Sarbati has lost its significance for from the date of amendment.
That is the view that the Delhi High Court and Madras High Court are taking. But what I would submit, my lords, is now this provision post 2014, all policies would be governed by this. So it is retrospective in its operation. What I am trying to make out is when the Supreme Court pronounces a judgment 9 years after the amendment and still approves of the law in Sarbati Devi.
No, even today, if Sarbati has to be considered, then there cannot be any two opinions that unless a different view is taken, there is no judgment to the effect that Sarbati lays down incorrect law and Sarbati was incorrect. It has just been taken note of in the Supreme Court's decision in support of the reasoning which the Supreme Court was going to find.
While interpreting a more stringent provision.
Right.
That is one. And second is, of course, Sarbati can be good law for makers of policies who have died prior to 2014. Because this amendment...
No. Sarbati is a good law. Sarbati, the law which has been laid down, the interpretation made by the Supreme Court, that is correct.
Keeping in mind the earlier provision.
So the judgment does not, the judgment is judgment.
My lords.
Judgment interprets a provision. Now, because the provision has been changed, therefore, the law laid down by Sarbati becomes incorrect.
No, I'm not saying that it is incorrect. The Honorable Supreme Court...
losing its significance even.
The Supreme Court, my lords, uses these expressions these days. I have given 2 instances where they say that the law laid down in Sarbati Devi is legislatively overruled.
No, legislative overruled.
This expression is being used, my lords, the judgment also I have given. So this is a case where if we follow the interpretation, the law which has come about, then Sarbati Devi loses its significance because it would no longer govern policies. Because once this provision is interpreted in the literal manner in which the Delhi High Court has interpreted it, then...
So where is that expression?
Legislatively overruled. I will show that, my lords. Bharat Sanchar.
Legislative overruling is entirely different concept.
That is what the Honorable Supreme Court says in the context of the Arbitration and Conciliation Act, where 34 was amended. So in the context of that they have used this expression that suppose an amendment comes in and it takes away the effect of the old law, then they have used this. Paragraph 30.
Paragraph?
Paragraph 30, my lords.
To legislatively overrule.
Paragraph 30. The amendments to section 11 were brought about to legislatively overrule the line of judgments including SBP, Bhogra, Master, so and so. So all that I'm trying to show before your lordships is, since Shakti Yazdani in 2023 doesn't use these expressions vis-a-vis Sarbati Devi, it cannot be presumed that, and it cannot be presumed that they were not aware of the amendment. Because the amendment came about in 2014. So it can't be presumed that the Honorable Supreme Court in 2023 was not aware that 39 has been amended.
Can we presume the converse?
Plus they were aware, and still then they held that Sarbati Devi is to be approved. Otherwise, they would have used something similar. That the amendment, if I can add this like this, the amendment to section 39 were brought about to legislatively overrule the line of judgments in Sarbati Devi and other. So that's what I'm trying to make out, man.
Which paragraph you are referring to in this?
BSN versus Nortel, para 30. At page 759 on the right hand side.
No, that is when it is decided to overcome a decision rendered by a court of law. Then you may call it legislative overruling or. Was this the situation here also?
Here also, if your lordship sees the Law Commission recommendations, they want to get out of the situation in Sarbati Devi. Because they did refer to Sarbati Devi in 1984. And then they came about with this concept that there should be two nominees, beneficial nominee and collector's nominee. And they said that we will not be able to accept that the entire money goes to the nominee.
We are of the prima facie, of course, that the mischief rule will apply here.
But what troubles me, my lords, is this. 109 capital A, if they have interpreted that to hold that no, still then the nominee will not get it, then 39 has a much more diluted provision. How can that be interpreted to be in favor of the nominee? So my point flows straight away from there. And while saying so, I'm trying to persuade further your lordship with this BSN, Nortel and these expressions.
Yes.
Independently, my lords, your lordship, this point of mine may not find favor with the court, but what I'm trying to show is that point number 7 of my note, that it can't be presumed that on 14/12/2023, the Honorable Supreme Court was not aware of the amendment to section 39 of the Insurance Act. That presumption can't come, my lords.
There is no mention.
There's no mention. There's no mention, of course.
No mention, no discussion, nothing. So how can you?
So then we would have to presume that they were aware of the amendment to section 39. And still then they have held this. And till this law, my lords, is changed by the Honorable Supreme Court, this has to be, then those judgments, my lord knows, this would be binding on the High Court.
Since they were dealing with the law prior to the amendment, why should we presume that they were aware of the amendment?
In fact, what he is trying to submit that to support their reasoning in case of that Sakti, they, you can say they accepted the reasoning assigned in case of Sarbati.
They accept, if I can take that a step further, they accepted the reasoning of Sarbati and approved.
They supported their
reasoning with Sarbati
by the law laid down in case
Sarbati,
of Sarbati.
Which is contrary to the amendment. If your lordship sees, Section 109 capital A straight away says that no questions asked, the money has to go to the nominee. The virus of that provision was not under challenge in this case. Still then they held that no, it can't be given to the nominee. The laws of succession will prevail. And the words used in 109 capital A are quite strong. West, notwithstanding any testamentary disposition.
Let us compare again the pre-2014 and post-2014, section 39.
My lords. So the basic point that I'm trying to make is till Shakti Yazdani holds the...
No, we are trying to read from the language of the earlier provision before amendment and after amendment. So that will throw some light whether to take a different view than what has been taken by the high courts and accept the logic in case of Shakti. Yes.
Subject to the provisions, sections.
You are reading?
39 amendment.
39 pre-amendment, what is there?
Now, if your lordship is holding this professional that has in slightly even smaller letters.
Yes,
the
nomination by policy holder.
My lords.
So there is no difference here.
So the small print is before the amendment.
Small print is before the amendment.
Yes.
But clauses 1 to 6 are unamended.
Where is the
change has
Change
happened
comes
in
from
clause
7, clause 7.
7. Clause 7 was introduced. And a deeming clause was also added, which has the effect that in fact, your lordship was absolutely right while analyzing the Madras High Court. The Madras High Court says that only specified people can be beneficial nominees. If it's a brother, you can't be a beneficial nominee. So the literal interpretation of this provision is what the Delhi and the Madras High Court have held. But they didn't have the benefit of this Shakti Yazdani. Shakti Yazdani has come about later. And none of the high courts, including Karnataka High Court, have analyzed it in this manner. But now, in view of Shakti Yazdani, this should be, that's my submission.
Subsection 6 was not there, no?
My lords.
Subsection 7.
7 wasn't there. 7 has been introduced. 7, 8.
Seven to 12, my lords, have been added new.
Yes.
If I can come back to my note, Miles, I'm sorry to bring back to that note. Now, dismissal, because Delhi High Court, the view against me that was carried in SLP was dismissed in limine. That effect may not have much, but those judgments I have given. So all this, Your Lordship, just for convenience, I have given this. Obiter of Supreme Court is binding. We'll provide all copies. We have mentioned the judgment and the para number.
Yes.
Now, there are a series of judgments in favor of the appellant. We have mentioned all of that, including SLP dismissal and all, which my friend had missed.
Yes.
So page 5, judgments of various high courts, serial number 10 of my note I am placing. Judgments of various high courts in favor of the appellant. Delhi, SLP was dismissed. Then Andhra Pradesh, Madras, again Andhra Pradesh, Rajasthan, all these are against us. Now, judgments in our favor, that's at page 6, my lords, would be Karnataka High Court. Interestingly, against this also SLP was dismissed. And Karnataka High Court also takes note of the amendment. There are certain judgments which do not take note of the amendment. The Karnataka High Court takes note of the amendment. So at page 6, I have listed out 7 judgments in favor of my clients. Wherever amendment is not taken note of, I have also mentioned. So we also have Guwahati, which I would like to show your lordships. And with that, I'll end. I won't take much time.
So this Karnataka judgment, how does it explain the amendment?
I'll show that they just take note of the amendment and say that in view of Sarbati Devi.
That is the thing.
Our best bet would be the judgment in Shakti. Yes. What I'm trying to show, my lords, in Guwahati High Court, my lord, may kindly see. Paragraph 17, 18 and 19. Now, why I'm saying this, my lords, normally a party, why I rely on this, this was in the context of this amendment also. Here the amount in dispute is 50 lakhs. The claimant is the grandmother, my friend for the appellant, he is appearing for the grandmother, and I am trying to protect the interests of her own grandchild. So normally a party who suggests what has been suggested in paragraphs 18.
Grandchild is in the custody, whose custody?
Of the father.
Father.
So what I am trying to, normally a party who seeks mediation or who seeks out of court settlement, it's not that I have a weak case, but in the context of the amount involved and what is, who all are the warring parties, if this can be settled. Because ultimately what we are looking at is a long drawn battle somewhere else.
No, but what is
so in that
paragraph 13?
17, 18, 13.
13.
Here, my lords, 13 again, they take note of the amendment.
No. In the Guwahati High Court's decision.
My lords.
Saying 17, 18, 19 is relevant also.
Because after interpreting this, they have referred it to mediation.
No, but that contains the reasoning.
My lords.
Paragraph 13.
13. A careful perusal of the aforesaid subsection in the opinion of the court would make it clear that if a nominee is a spouse or children or parents, the nominee would be entitled to such beneficial title as permitted under the law.
So if, here the court draws a distinction. If a nominee is spouse or children or parents, then the nominee would be entitled to such beneficial title as permitted under the law and law of succession. And then the meaning sought to be given by the so and so that entire amount would be entitled. is not correct meaning.
So here,
So just we can read this. If nominee is not a spouse or children, then
or
the nominee
parents.
would not be entitled to such beneficial title as permitted under the law.
Well, that is the interpretation. I'm not so.
How can we read this? How should we read this sentence?
That's the reason, my lords, various high courts have interpreted it in their own way.
Differently.
Even, in fact, one high court has said that the amendment has not come about. So that's the reason why I didn't show those judgments. But what I was trying to say, my lords, that this is, of course, I'm not suggesting, because these parties are at loggerheads.
Nominee would also be entitled exclusively or just?
Subject to laws of succession. Now, if we here the person who died was a lady. So if we go by the law of succession, then the mother wouldn't get it. The grandchild. Had it been a male member, then the mother would.
No, if Guwahati view is accepted.
The High Court views, my lord, with great respect to all of them. Some of them have also missed that some of them have said that the amendment is not come into force. Hence, they would take. So basically, all these high courts are following Sarbati Devi. And they are quoting Sarbati Devi, and then they are saying that law of succession will be. Otherwise, also, my lord, till the Honorable Supreme Court finally takes a view.
It's not the case that when the case was decided by the High Court, amendment may have come in. But when the occurrence took place, what had happened?
No, the amendment governs all policies, even if they are made prior to the amendment. The only case where the amendment would not apply if the policyholder had died prior to 2000.
But if you read carefully subsection 7 and 8,
my lords.
Subsection 7 says, subject to other provisions of this section, where the holder of a policy of insurance on his own life nominates his parents,
my lord,
or his spouse, or his children, or his spouse and children, or any of them. The nominee or nominees. Nominee or nominees means nominee or nominees only. Shall be beneficially entitled to the amount payable by the insurer to him or them only under subsection 6, unless it is proved that the holder of the policy, having regard to nature of his title to the policy, could not have conferred any such beneficial title. So if he did not have the ability, then otherwise we can read only, we can add only at two places, which I read, and only is not there. Now then come to subsection 8. This clarifies. It says, subject as aforesaid, where the nominee, or if there are more nominees than one, a nominee or nominees to whom subsection 7 applies die after the person whose life is insured, but before the amount secured by the policy is paid. The amount secured by the policy, or so much of the amount secured by the policy as represents the share of the nominee or nominees show dying, shall be payable to the heirs of legal representatives of the nominee or nominees. So that is confined to the nominee or nominees, or the holder of succession certificate, as the case may be.
8 would apply in case the nominee dies. 8 visualizes a situation where the nominee dies.
Nominee dies, but the right of the nominee is confirmed here.
Confirmed, yes.
Because
So
even
a
if he
literal
dies, his-
interpretation, a literal interpretation.
Only his legal heir or
Correct.
her legal heirs will
So,
be entitled.
my lords, there is no doubt that a literal interpretation.
Party view is apparently not a
something-
correct view.
I don't. I had shown Guwahati only for mediation. So there is no doubt that the literal interpretation of this would be in sync with what the Delhi and Madras High Courts have.
No, then yes, you are right that literal interpretation of Section 109A of the Companies Act has also been made by the Supreme Court in
Yes.
Sakti.
And
the
109A, the language is much more stringent. So I'm banking on that till now. Tomorrow, if the Honorable Supreme Court decides to review Shakti Yazdani and takes a different view, then I'm nowhere. But till Shakti Yazdani holds the field.
No, we don't know. In future, the Supreme Court may follow the law laid down by in Sakti and interpret Section 39. We don't know.
In view of why I read out now, if I can say that, why I read out the recommendation of the Law Commission is this. Because there, all these, only the one private player has said that this should be the law. But if your lordship sees the recommendations of all the PSUs and the major players, it was that don't have such a situation. So the basic recommendation of the Law Commission, they are trying to bring in a regime where the policyholder makes a conscious choice that yes, I'm either going for a collector nominee or a beneficial nominee. But now the present provision doesn't give that choice at all. It's simply you don't have a choice. But what the Law Commission recommended was you give a specific choice. Make a distinction between a collector nominee and a beneficial nominee. Here, by way of a deeming clause, they have made it so that unless it is mentioned, it will automatically go to the beneficial nominee. And they have come about with that who can be a beneficial.
For the amount to go to the legal heirs, the person is to nominate only the persons who such relations whose description find place in the. Otherwise, if he nominates any person other than those mentioned in Section 39, the law of succession will apply for.
Yes, that's the position. In fact, the Madras High Court clarifies that. Your lordship may recollect, your lordship had read out that paragraph on the last date. In Madras High Court, the brother was named as the nominee. And there, while interpreting this, it was held that since he is the brother, he won't get it. Only these persons are entitled to be the beneficial nominees. So there is a conscious choice.
If the brother, it will go to the successors.
Or the testamentary, whatever, testamentary disposition will. But till 109A and its interpretation is changed, I don't think what the Delhi High Court.
A nominee to be
beneficial nominee.
Beneficial nominee cannot be outside the family.
No, brother is within the family.
Specific.
No, friend. But this specifies a particular class of people who can be
This
beneficial.
is what we are saying.
Yes.
Friend?
No.
No.
So if he nominates any person other than
Outside
those
the specific person in the family.
I'll give an extreme example. In case of my life insurance policy, suppose I nominate my driver, he will not get the money. If this amendment is
even if you wanted,
even if I wanted it, he won't get it.
So you don't have any choice under the law.
I don't have a choice. As on date, I don't have a choice to make a life insurance policy in the name of my driver. I can make it, but he is just the collector. He will collect it and he will thereafter give it to. If I really want my driver to get it, then I have to have a will in place. Then in terms of the will, he will get it. A separate will. So there is a conscious effort of the legislature to bring this. But my point still, at the cost of repetition, if I can say,
yes,
that Supreme Court judgment will stare at the interpretation.
The
the letter.
reasoning, the reasoning applied in case of Sakti.
And to my luck, my lords, they have also taken note of 39 and Sarbati Dev. So there is, that's why I say, my lords, it's arbiter, but still then that is till the High Court's, till the view is changed, that will be the law.
Let us.
I'm deeply grateful, my lords.
Yes, Mr.
Yes, may I make some points, submissions?
Yes.
First of all, my learned friend has fairly conceded that the challenges to the Delhi High Court upholding 39(7) and Karnataka High Court, I appreciate him that they have been dismissed by the Honorable Supreme Court. So we can't say that Honorable Supreme Court has not taken a view on this issue.
No,
Secondly,
because those orders are in limine, therefore it can't be said that law has been laid down by Supreme Court on this point.
Please, my lords. But my lord, the limine, when a petition is dismissed in limine, my lords, that means that it is not, it has no merit to be considered.
All right.
Number
Yes,
one.
next.
Number two, my lords. So far, my learned friend has laid much emphasis on the recommendations of the Law Commission, that is, which introduced the concept of collector nominee and beneficial nominee.
Yes.
But my lord, the legislature, in its wisdom, has done away with this distinction that the nominee, that the holder of the policy should specify the as to whether the nominee would be a collector nominee or beneficial nominee, and has used the term beneficially entitled. That is a special class of nominees would be beneficially entitled. So this
He is
is
not
the
arguing that.
Please.
He's not saying that. He's not saying that there is. We should read the law in the light of Law Commission recommendation.
Please,
So
right,
Law Commission's recommendations have not been accepted in toto. This is what he has
Yes, yes. Then my learned friend lays emphasis on Shakti Yazdani's case. But Shakti Yazdani case, or for that matter, a number of other cases have been also laid down, interpreted by the Honorable Supreme Court, which has been also been taken note of and interpreted in support of his judgment. That is Indrani Wahi's judgment. And also my submission is that they have been passed in a different context, in the context of the Companies Act. And Indrani Wahi's judgment, which the learned single judge relied upon, was passed in the context of Cooperative Societies Act and interpretation as to the rights of the nominees and the rights of the legal heirs by way of succession.
Right.
Then similarly, my lords, in Employees Provident Fund Act, National Savings Certificate Act, and other acts. So, my lord, interpretation given by the Supreme Court in the context of one statute cannot be applied in the context of, yes, it may have some value for just for reference, but the ratio laid down in one judgment in the context of one, the terminology used and the purpose in one act cannot be used in another. So this Yazdani's case does not have even the persuasive value for the reason that 39(7) is a conscious exception carried out by the legislature in favor of a particular class, of very limited class of nominees.
All right.
So this is my submission. So my learned friends, this Shakti Yazdani is not having any effect or any the arbiter, although it is an arbiter, but can't be considered.
Mr. Parashar, his submission is that there is no law laid down by the Supreme Court interpreting section 39(7) of this act. This is one. And what he submits, that there is more stringent provision under the Companies Act, which has been interpreted by Supreme Court in a way that has been done in Sakti. So therefore, he is trying to derive a strength from Sakti for the purpose of interpretation of section 39.
Please, my submission is that we have to Yes, please, my lord, sorry.
According to you, it may not have persuasive value, but this is what he is saying, that on 39 there is no Supreme Court judgment. On 109A there is Supreme Court judgment. 109A has more stringent provisions, and therefore the provisions should be read accordingly. This is what he submits.
Please, my lord.
Yes,
But
next.
my lord, please, but that is, we have to, there is the, golden rule of interpretation is the literal interpretation is the golden rule of interpretation from ages, which we have been following.
But that
the
Supreme
statute,
Court did not follow in case of Sakti.
please, my lord.
In case of Sakti, the Supreme Court did not follow the golden rule which you are suggesting.
But my lord, the Honorable Supreme Court in Shakti Yazdani holds that the legal heirs it would be go by the succession, because that was in the context, the language used in the section 109A
Language
of the,
use is stricter, Mr.
Yes,
Parashar, in section 9A.
But my lord, we cannot draw any strength from interpretation given by Honorable Supreme Court in a different context, different statute, different provisions.
Please.
So it can't be transposed.
Yes, sir.
Yes.
Various High
So-
Court judgments.
Next.
Various
So
High
next-
Court judgments will
next
leave it
one.
separate.
So my lord, the statute has to be read literal interpretation, given literal interpretation, unless there is any ambiguity, unless there is any vagueness, unless there is any confusing word terminology used, and the purpose, intention, and of the legislature is very clear.
All right.
So that has to be that the nominee and section as read by my lords, section 8 and 10, and I'll also
You have submitted your written notes of argument, Mr. Swaraj.
Whereas I have already submitted, and if I can, if a director, I'll be submitting once again.
Thank you.
So that is why we have come to the Honorable Court to get a new interpretation as per the statute, amended statute.
Judgment to them. Yes.
Please, brothers. Much obliged.
Item note 30.
Yes, please.
May it please your lordship, as per order dated 22/10/2024, Collector cum District Magistrate Raigad was directed to file a affidavit. The affidavit has not been filed. Kind request for a 1 week time for filing the affidavit.
This is regarding electrification.
Electrification, communication, and ASA and Anganwadi centers. Nothing is available there.
So in one petition, you can
No, that is the village problem.
make the High Court to.
No, my lord.
Yes.
My lords, with respect to
File your affidavit
yes, my lords.
as soon as it is possible. How much time?
My lords, 1 week, 2 weeks
2
maybe.
weeks.
2 weeks.
2 weeks. Further time is allowed for the state to file counter affidavit as was directed earlier.
Even today, nobody has visited the village also. As per after minor's direction also, nobody has visited the village.
So they will file counter affidavit from the office without visiting.
31.
And in last occasion, your lordship had directed state to file counter affidavit, but they have not filed.
Further 3 weeks time may be
2 weeks, madam. 2 weeks.
That's I am entering appearance for OP 10 to 13. I filed my wakalat.
10 to the so enters appearance. Masha. That order is there.
Yes.
All right. Yes.
Item 32.
Great. My lords is keeping it up to 2 weeks.
2 weeks.
Great.
May I submit matter? Your lordship, the tender, it is the matter for production of documentary film. Under production of documentary film under the banner of Special Development Council, Mayurbhanj. Tender was invited on 8 November 2018 for production of documentary film.
Yes.
Then supply order was issued on 11 December 2018.
11 December 2018.
Supply order was issued to me. Supply order, work order issued. After that, in supply order, it was instruction was given me that my quotation submitted by this tender was accepted, and I was instructed to initiate the production of documentary film within 21 days from receipt of this letter. And also instruction given to submit the script within a week period for the perusal of the collector, COSDC Moyurbhanj.
Yes.
And I also submitted the script within a week period, that is on 19 December 2018.
Yes.
Then, as for the work order, I started the production because there was a conditional order was in this work order.
When did you give the script?
I deposit script in 17 December and 19 December in 2 phases. Because I got the supply order in night 8 PM on 11 December. By mail only.
Been asked to give within a week. All right.
Then after that, after instruction is that if a non-production of the above, that initiation of the production and submission of script, then the MD will be forfeit and the order will be cancelled. So I make these things and then I send the documentary film on 30th June 2019.
2019.
2019.
Yes.
That is the documentary film with raw DVD was submitted in the office of the SDC. After that, I send a invoice along with the letter for the disbursement of payment. No reply has come from them. Then I send a reminder on 15 August 2019. Also no response. Then I send a second reminder on 8 September 2019. Also no response. Then I send the legal notice on 10th February 2020. After getting the legal notice, the opposite party number 1 and 2 send a reply. Reply was received by me on 28th February 2020.
You had sent the legal notice under which provision?
Provision is that I had submitted the scripts and for the script I need some payment.
No, did you, whether the legal notice was under section 80 CPC or what?
I don't know, sir, under section.
Is there on record?
Yes, sir. This is on record. Legal notice.
All right. When did you receive reply? 22?
Reply legal notice 28 February 2020.
Yes.
In this legal notice, the opposite party 1 and 2 stated that the file was not processed because the SDC was dissolved due to the code of conduct and the chairman of the SDC has been resigned from their post and the file has been being held for the perusal of the chairman after joining of the chairman or after formation of the SDC. Then which challenge this letter on this Honorable High Court that in case of absent of the chairman, then...
So you challenged that?
Yes.
You challenged? You challenged?
Challenge means we prayer to Lordship Court.
You filed a writ petition?
Yes, 2020.
2020.
By WPC 26959.
26959.
Yes. By this writ petition, this Honorable Court giving me the liberty that the loan collector will disburse the Annexer 8 in absent of chairman. Without merit of the case, this Honorable Court giving me liberty. This was only prayer that if the chairman is not there, then we will disburse the file. This Honorable Court giving me liberty and instruction given to the opposite party to disburse the file within 30 days without going to the merit of the case. Then collector given me time opportunity to state about the facts. After that, collector dismissed my representation with a merit that the script has not been approved by the council chairman, which has already stated before the legal notice reply 104, same thing. the script is not approved. And the rejection of the my annexure 8 representation was the same, that the script is not approved. Then my prayer at that time to the collector that, so please allow my work order till the formation of next SDC. This is also written in this application. Then I wait for the formation of SDC. Then after that SDC formation in 27/9.
What is SDC?
Special Development Council.
Yes.
Then SDC formed in 27/9/2022. After that, I sent 2 letters for the process of the file in 10th February 23 and 24/7/24. That SDC has already formed. As per your legal notice reply, the SDC is not here and chairman is not here. This file is waiting for the approval till the formation of SDC. Then no reply has come from them. Then another application I made in 24/7/2024. Also no reply came. Then I take shelter of this honorable court. Where
is the work order?
Yes, my lord.
Where is the work order?
What? Work order. Work order is in Annexure 3 in writ petition. Page number 17.
Yes. So where is the? This is 11/12.
The work order is 11/12/2018.
Yes.
May I read yours?
Yeah, that we have seen. So you submitted your script.
Script submitted in 17th and 19th.
Yes. Was there any requirement that your script should be approved?
No, there is no line approval is written in the tender call as also in supply order. Approval word is not there. That approval of after approval, because the scope of work already attached with the work order.
No, script is essential. That is required to be approved. There must be some provision. Otherwise, you can write anything and prepare your documentary. You must have something. Yes, where is the notice?
Yes, my lord.
Where is the notice? Where is the tender notice or
Tender
whatever
notice is Annexure 2 in page number 11.
expression of interest?
UI.
Whether a counter affidavit has been filed?
Yes, Your Lordship.
So on what ground you are denying?
Your Lordship, this very same prayer was espoused by the petitioner in the previous writ, Your Lordship. And the collector has passed a reasoned order. That order was never challenged by him, and it has attained its finality, Your Lordship.
Where is the order?
The order of the collector is at page 63, Your Lordship, of the writ petition.
Annexure?
There's annexure. Annexure 11 series, Your Lordship, page 63. The first para, if I may place, Your Lordship. Whereas the above mentioned petitioner filed a writ petition before the Honorable High Court Orissa in WPC number 26959 of 2021, seeking direction to the opposite party for disbursement of the bill under Annexure 4
and disposal of the representation under Annexure 8, Your Lordship. The collector, Your Lordship, at page para 2, Your Lordship, at page 64. Last, Your Lordship. In pursuance to the above work order, Your Lordship, the work order was conditional, Your Lordship, that he has to submit a script within 7 days of receiving this work order. The script, after the script is approved only.
Where is that word approved?
Lordship, it meant that because
we are unable to find that. We have been looking for that.
The tender call notice, it was twofold.
Yeah.
One was a technical.
No, but please come to page 65.
Yes, Your Lordship.
It refers to, in view of the above, I am of the opinion that when the script submitted by the petitioner were not approved.
Yes.
And the petitioner himself had undertaken.
Yes.
That after approval of the script by purchaser, it will take minimum 30 days to supply.
Yes,
So
Your
some
Lordship.
letter must be there.
Yes, Your Lordship. I have annexed in my reply affidavit annexure F/2 series, Your Lordship. Page 8.
And did you ever challenge this order?
No, Your Lordship.
I have not challenged this order because I am waiting till the formation of SDC, because if the formation of SDC, then the file will be processed. They will process the file and I will do
No,
the
where
work.
is the question of formation of your claim was rejected on 24/8/2021. Where is the question of your waiting for formation of anything?
Your Lordship, in tender call notice,
And in the tender call notice, it's twofold. In the financial bid, Your Lordship,
page number 50.
clearly it has been stated finance is to be released pre-production, production, and post-production, Your Lordship, as and when he raises the bill. So neither there was any pre-production bill raised, nor production bill raised, nor post-production bill raised. There was no approval of the script, Your Lordship.
Post-production, Your Lordship.
He raised altogether, all of a sudden, he's raised the entire bill, Your Lordship, and Annexure 15 to his rejoinder was never received by the office, Your Lordship. And Your Lordship may see F/2 series, Your Lordship. He's submitting the script, Your Lordship, and he's saying that all the above documentary will be made on regional language as order of purchaser, and the same shall be scrolled in English language. After approval of script by purchaser, it will take a minimum of 30 days to supply the finished documentary, waiting for your approval.
Where is that?
Annexure F/2 series, Your Lordship, of my reply affidavit, Your Lordship, to his rejoinder.
Counter affidavit, it is not there.
No, Your Lordship, because the collector's order clearly reflected the same, Your Lordship.
Which an F/2?
Yes, Your Lordship. It is dated 17/12/2018, and another is, the next page is 19/12/2018. In both the sets, he's written that. He's also waiting approval.
Documents. He gives sets of documents, they give some.
And he refers to the supply order dated 11/12/2018. There was no intimation of approval of his scripts whatsoever from the authorities.
I think when he submitted the script, he gave this letter.
He gave an undertaking also that after approval, I'll take 30 days.
Which is correct. After you approve, I will
Yes,
do
yes,
the right
Lord. Because he might give anything in the script. It has to be approved.
No, one thing he might give anything. Second thing is, if he goes ahead without your approval, you will not pay also.
Yes, Your Lordship. And that too, he has given the DVDs in the month of June. That is after 6 months of his submission of script.
No, that he waited for your approval.
And in another matter, subsequent matter also, Your Lordship, he's been blacklisted by the authorities there, Your Lordship, because he's given a forged check of 2 lakhs.
That is different.
That is different.
Where is the rejection?
And annex the 11 series, Your Lordship, at page 63 of the writ application.
Actually, 11 series is parawise comment.
11 series. He's given the annex the entire writ petition. So the last page, 63 to 65 is the rejection order.
525 is a parawise of comments. Acha, thereafter. Parawise comments. He has annexed your Parvez comments.
Your Lordship has given me the, our copy has the entire writ petition, Your Lordship.
What is the date of rejection?
It is, Your Lordship, 23rd August 2021. 23/8/2021.
Yeah. And when did you file the writ petition?
Filed one earlier, I think.
26/7/2024.
No, before that.
Before that.
This rejection is pursuant to the order of this
9th
court.
10/2020.
All right, all right.
9/10/2020.
Yes, we will pass out 2 weeks. Two weeks, huh? Judgment में डालना order for change.
My lord, supply orders are not cancelled till today. I mean, my EMD also at opposite party till now.
Item 33.
May please. Lordships, pursuant to your Lordship's order dated 5/10/2024, completion certificate has not been received, your Lordships. My lords, I have oral instructions to that effect, but I don't have written instructions. Kindly, the matter may be taken up next week.
What oral instruction do you have?
That certificate has been granted and up-to-date payments have been.
As requested by learned ASC, representing the opposite parties, list this matter on 1 week.
My lords. Pardon, your Lordship, through post one credential certificate has been issued by them, where it has been written that under the heading, whether the work is complete, that has written no.
When?
And it is dated 28/10/2024.
So let us hope he has received some instructions.
So regarding this, yes, sir, she may file a affidavit, but okay, yours. Next to Unit 6. Next.
Item 34.
That case, I am appearing on behalf of the OP number 4 institution, that's institution, in which the student concerned, the petitioner before Lordship is reading Miller. I am, for your Lordship kind appreciation, I have filed a very small affidavit, that is counter affidavit, that is that flag, and that flag B of your Lordship brief Miller. I have already served the copy of the counter affidavit on the Learned Counsel appearing for the petitioner Miller. What are the relevant portion of law that has been laid down by the DPUT, that is the university, which is also a party in this case, Miller, OP number 3, regarding intertransferability of the student Miller? I'm just, your Lordship may kindly appreciate my counter affidavit and flag B of your Lordship.
You are for the petitioner.
OP number.
No, I am for the petitioner.
I am for the OP number 4 institution in which the petitioner.
You will argue on behalf of petitioner also.
No, sir, move it up. Sorry, your Lordship, I have filed the counter affidavit. It has come before your Lordship for the first time.
Yes, yes.
First time.
In case he wants time, he will ask. If he is ready to argue, we will hear.
Very well.
My lord, the counter affidavit, page 6. They filed the counter affidavit, page 6 of the counter affidavit, my lord. The Synergy College has specifically mentioned that all the records of the petitioner has been submitted to BPUT for necessary advice and instruction. The BPUT will take care of that, and BPUT, advocate for the BPUT is, yes.
I have not received a copy of the counter affidavit. Just now I am serving it, Miller. I have already served the AICT. You are not there, so that's why I could not serve. I am just serving, Miller. Just now I am serving. You may kindly take note of it.
Who are you?
Miller, I am the OP number 4 institution in which the student concerned is prosecuting her first year study, Miller.
And
BTech study.
Who are you?
I am for BTech, Miller. OP number 2, man.
University.
University.
What is your stand on?
Miller, my stand is Miller. Your lordship may kindly come to the BPUT regulation, Miller, academic regulation, that is page 19 of my counter affidavit at flag B of your lordship brief, Miller. Miller, this regulation itself says, Miller, that is starting from page 19 of my counter affidavit. Under two circumstances, Miller, 19, your lordship may kindly got it, Miller. And 20, page 20 is the very relevant page, Miller. Under two circumstances, one student is allowed to transfer from one college to another. That is extraordinary circumstances. Under the extraordinary circumstances means the closing down of the college or withdrawal of the affiliation or approval by the AIC. It is not coming under that ground, Miller. Then second is that is on medical ground, Miller. In medical ground, Miller, the student concerned has to apply the concerned institution in which it is reading, she is prosecuting her study, Miller, with proper format of the application, that is page 19. I have already annexed, and that format it has been prescribed, Miller. In fact, Miller, by the time of filing of this writ application, Miller, the students concerned did not apply to the institution. Then after seeking for amendment, Miller, they have applied it, and after getting it, we refer that incomplete application to the BPUT for consideration, Miller. Here the case is that your lordship may kindly appreciate the second consideration. What is the zone of second consideration permitting a student from transferring one institution to another is that, Miller. I am just reading out for your lordship kind appreciation. Clause B, Miller. Besides above, in the beginning of the academic session, 5 students per year branch of BTech program and 5 students per year for B Pharma, we are concerned to BTech, may be allowed to inter-college transfer from one affiliated institution oblique college private to another affiliated institution college private in the same discipline program on medical grounds subject to the consent and production of NOC from the principal director of the both colleges. No student from one government college to another government college shall be allowed to transfer unless it is in rarest of the rare case. Under no circumstances, the inter-college transfers within the city within 50 kilometers distance shall be allowed. Then it is very relevant. The second one is that the penultimate para of that clause, Miller. The inter-college transfer is not allowed in the first year and year of admission, and further the inter-college transfer from one affiliated college to a constituent college, vice versa, Miller. Here in this case, Miller, the student concerned, he has already completed 1 year course, Miller, but your lordship may kindly appreciate his mark sheet. Her mark sheet I have already annexed annexure 1, Miller. I have already referred all of the documents for the consideration of the BPUT, Miller. She has not completed 6 papers. 1 paper each year consisting of 2 semester examination. A course, BTech course is comprising of 4 year studies, Miller, and each year consisting of 2 semester examination. In 1 semester examination, she has not completed 3 papers, Miller, and the second one,
so that is because of you or in spite of you,
Miller.
She could not clear the papers because of you or in spite of you.
That semester examination is conducted by the BPUT. We have no role to play.
She can clear the examinations if you teach properly. If you don't teach, then say.
Miller, most of the students have cleared, Miller.
Most of the students might have cleared, but how many students have cleared?
Miller. So anyway, Miller, 6 papers.
Tell us.
Miller, 3 papers in the.
All right.
Miller.
So the matter is pending with the BPUT right now.
Miller. The another difficulty. Yes, Miller.
The matter is pending with the BPUT.
Yes, Miller.
BPUT has to take a decision for transfer.
Yes, Miller. It is the BPUT.
Today morning only I took instructions from the law officer. Actually, his oral instructions, they have not received any medical documents. Those medical documents have to be put before a medical board of OJU. Unless and if the medical board approves that, after that we'll give our approval and send it to the.
All right. What is your medical condition?
Arthritis and psoriasis.
This is the photograph, my lord. I have annexed
all right. So you have not sent the medical document.
Miller, we have not received whatever documents we have received during the pendency of this writ application under annexure D/4 series. We have referred it.
Have you given the medical document?
Yes, that is in the annexure
No, next year you have submitted here, whether you have submitted those documents before the.
Along with that application, we have submitted.
Huh?
Along with that application, my lord, we have submitted all the documents. To
Yes,
Synergy.
whatever.
If necessary, I can
Don't
submit
say-
again.
Say that because the application does not say that I am enclosing medical documents.
Miller.
Your application is at page 24, Annexure C/4. So they have enclosed the application along with the letter.
All right,
to
what
the
have you
BPO.
forwarded?
Miller, that is under annexure D/4 series. Your lordship may kindly turn to D/4 series. We have forwarded starting from page 21 of my brief, Miller.
D/4 there is nothing.
Miller, whatever documents, Miller, that is
C/4 it is there.
D/4.
Usually no reply.
D/4 series. D/4 series 21,
Yes,
page 21. Your lordship may kindly, that is our 27/9/2024 letter, Miller, to the universities,
One moment.
University, Miller. And we have submitted whatever the documents under annexure.
Very difficult, Mr. Whatever means what? You know what was submitted.
Miller, that is the letters by Bhagyalakshmi Mahanti. I'm just reading out the enclosures, Miller. Letter applicant dated by post of Ethiki with the former SCA. That is the concern application, Miller. That is the application form submitted by the petitioner under ACA-12 formula. Whatever application has, for detail, if your lordship want to make a query, I can convey your lordship.
You are supposed to give the detail in your counter. You have given that.
Yes, Miller.
Yes.
Annexure
Do not delay whatever.
Yes, you are also not very clear whether you had submitted the your medical certificates or not.
Medical certificate, my lord, whatever document were there.
See, this whatever explanation is very difficult to understand.
I shall submit tomorrow
Say
all
that.
the documents again to the BPT directly.
So till date you don't have any case.
Yes, my lord, all the documents.
What case?
All
Those
the documents are
documents
here.
medical documents. You had submitted.
Yes.
You have not submitted.
All the
Whatever.
documents.
What is the date? Date of that document. Clear. Not try to. Please pass it over there.
5/9/2024.
5/9.
Yes,
So the
41.
very day you got your medical certificate, you issued that letter.
Along with that letter,
All right. Letter is dated 5/9. All those documents are 5/9 or how many documents are there?
10 documents.
10
pages,
documents.
10 documents. Page 29.
Peculiar facts, just in the peculiar facts and circumstances of the present case, we permit the petitioner to submit a fresh, if already not submitted, the certificates / medical prescriptions before the principal.
Principal, Miller.
Before the principal of which college?
Synergy
OP
Institute.
number 4, Synergy College of Institute.
Synergy Institute of Engineering and Technology.
Miller.
Canal. OP?
4.
In support of his her medical condition. Medical health
Condition.
health conditions. By tomorrow, in support of her application for inter-college transfer. So stop. If the documents are submitted by tomorrow, if such medical documents are submitted by tomorrow, the same shall be sent to the BPUT forthwith. Where is this college?
Miller College at Dhenkanal and BPUT is Raulkela. Dhenkanal is 60 kilometers from here, Miller. This is district headquarters.
Stop. List this matter on.
2 weeks. Submit
Week?
by.
Yes.
2 weeks to be taken up
Tomorrow by
with
the
first 5 cases. Within first 5 cases, stop. In the meanwhile, the court expects that the BPUT shall take a decision on the petitioner's request for inter-college transfer.
Tomorrow is holiday, your lordship can mention Monday, Miller.
Monday.
Is holiday.
Tomorrow ko Monday.
I shall submit by registered post.
Why do not submitting in person? You can show that it
You
is
do it.
here.
Do both.
Do it
Do
on
both.
Monday. Otherwise, you are going to lose so many things.
Lose your chance.
Positive. That will be done.
Don't miss this chance.
No, my lord.
And in your letter, you mentioned what documents you have enclosed. You have to be very specific.
Right.
Yes.
Don't say whatever.
35.
May I please, your lordship? The petitioner was awarded with the contract for doing the taxi service with the Jharsuguda Airport. Here the case of the petitioner.
Give your filing counter affidavit.
My lord.
File in the registry. Have you served a copy?
Yes.
Yes.
When?
Today he has given.
Want to see?
There, the lordship will straight away take to the award.
No, let him file counter affidavit first.
But now, after the notices were issued, they have given me a letter of termination. And they have said that you recoup the money, which has been recoup the money, EMD money, the money, some money was pending. Recoup the money.
What is that?
That was one of the condition that if you don't fail to pay in time, that amount will be adjusted from your EMD money. So now, under that basis, they have terminated. They have said that you recoup the money. My lord, I am ready to recoup the money, whatever it is. The case of the petitioner, in brief, is that he was given a designated plot inside to carry his business.
Let him file counter affidavit in the registry. We will take up the matter on Monday.
My only submission is I may be protected, your lordship.
You will protect it tomorrow. Monday we will take up.
Yes, your lordship. Till then, I may be.
Monday you have to be protected.
Waiting so long. I think.
Let the counter
Annexure
affidavit
12.
be filed.
I will file the counter.
In the counter will be filed in the registry. So stop. This case. A copy of the counter affidavit has already been served on learned counsel for the petitioner. Learned counsel for the petitioner does not want to file any reply to the said counter affidavit. So stop this case on Monday.
Protection, your lordship.
Monday. Anything another? Let it come on Monday. All right, Tuesday.
Interim protection, my lord.
No.
Till Tuesday at next
My
day.
lord, already fresh award has been given. Fresh award. Pursuant to the tender call notice, award has been finalized and the award has been given to the third party.
That is
That is one of the conditions. That is one of the conditions
Not
they
yet.
can give.
By
But
another
what
party.
they have done, your lordship, now they told me that you vacate that place in February 2024 without any written orders, nothing. I vacated. Then they did not give me the bills because I was paying for that place.
Oh,
also.
so you have already vacated.
I have vacated. I am operating from the canopy place.
All right.
Now they have served me after February. Now that you also vacate from there. So that is only my apprehension, your lordship.
We will see on Tuesday.
Item 36.
Please, your lordship. Item 36, your lordship, please to issue notice for regarding blocking of portal registration under the ground of principle of natural justice.
On the ground of natural justice.
Because the 23(3) provides before you blocking the portal registration, you have to issue show cause notice. They order dated 3rd October 2024.
So challenges on that.
Yes, your lordship. Okay. Sorry. Then your lordship, now in the meantime they have not filed counter affidavit. My specific now stand before lordships. I am on the proportionality because let they take instruction because the condition provides the minimum period of 90 days, which is supposed to be expired next week. whether they willing to extend that, my lord, unblock my portal registration even in minimum period or continue. That, my lord, I only request your lordships.
No, no, what do you want?
My lord, the minimum period of blocking of portal registration on the bid documents, 90 days, my lord. The
Minimum or maximum?
minimum, no maximum has been fixed, my lord, as per the tender conditions, and rule prescribe 180, my lord. Then the 90 days will be expired on, my lord, next week, my lord, Monday, my lord. Lord, since they have counter is not filed, I am only requesting your lordships whether they want to unblock within the minimum period or, my lord, that maximum. That's
Then they withdraw the writ application.
yes, lord. If they
Within the minimum period, they cannot do because that is the minimum period.
no maximum, my lord, my own proportionality, my lord, there is no maximum limit, my lord. So it cannot be indefinite duration, my lord, my humble submission, because the nature of the violation is only 3 days delay.
You want them her to seek instruction as to whether after minimum period they unblock or not.
Exactly, my lord. This, my lord.
How much time?
My lord, so counter 3 weeks may be granted.
My lord, 90 days is minimum
No,
period.
if you get that instruction before that, he'll withdraw the writ application.
My lord, I'll get the instruction by next week.
Next week.
Let's this matter on next week. In the meanwhile, AAC representing the state of Odisha shall seek instructions also as to whether the opposite parties shall unblock the petitioner's portal after 90 days, comma, which is the minimum period for which you are a contractor. What are you?
My lord, I am a C class to participate in the tender, my lord, C class contractor.
Minimum period for blocking a contractor's portal. A contractor's portal, what is that portal called?
Well, portal means, my lord, to participate in online bidding, I have a digital
So
signature.
you have been stopped.
I have not participated. It amounts to blacklisting.
So blocking you from the portal.
From the portal. I can't, my lord, they unblock.
Petitioner from the portal.
As per clause 24(3), my lord.
All right.
And if you don't intend to unblock, then you have to file counter.
Hello, bless.
Maybe pardon to mention, my lords. My lords, there is a CRLMP application that was listed before Honorable Justice V. Narasimhan. My lords, this matter is related to the Bharatpur police station case, my lords. My lords, Justice S.S. Mishra is listening to the matter, another CRLMC application. So my lordship said that the matter be mentioned before my lordship.
What is this about?
This is about a release of the mobile phone of the telephone of the army officer. But his movement, everything is under in the phone, whereas the plus this the other CRLMP application.
Honorable Justice Narsingh said that since Justice Mishra is hearing the matter, he may make the mention before the Chief Justice to assigning to that bench.
And another CRLMP also, which was listed in past orders in regards to that also. That's both the matters may be taken up on Monday because it's very urgent.
We'll see.
Other one?